I would claim for this 21627.
For the reasons mentioned in detail in the judgment, the impugned appointment of respondent number 5 is hereby set aside. However, it is also found that the petitioner is also not entitled to get preferential treatment as claimed by her in the presented petition. The state respondent is directed to, by this judgment, it directed to publish an advertisement for filling up the post of peon in Government Higher Secondary School, Jaluki, by giving option to all eligible candidates to apply for the same, and thereafter conduct a proper selection process wherein the respondent number 5 as well as present petitioner may also participate. And considering the period which they have already, which has already been lapsed during pursuing of this present litigation, the state respondent shall also consider appropriate relaxation of the age of petitioner as well as respondent number 5 if they wish to apply for the said post. With this observation, this writ petition is disposed of.
Item 25, RSA 128.
Unknown. I'll sign first page and last page only. Later on I'll sign. For reasons mentioned in the judgment, this civil appeal is allowed. And the impugned judgment passed in civil appeal 1 of the first appellate court is hereby set aside. However, the civil appeal number 1 is remanded back to the first appellate court to pass a fresh judgment in light of the observations made in this judgment.
Much obliged.
Item 26 and 27, WPC 1 and 2 2019 and WPC 9 2019.
WPC 122/2019. For reasons mentioned in this judgment, the impugned appointment order of dated 26/10/2018 of appointment of respondent number 5 is hereby quashed, and appointment of respondent number 5 to the post of medical attendant Chare is set aside. Considering the materials available on record, this court is also of the view that the present petitioner is entitled to get preferential treatment on the basis of his claim of land ownership. However, in view of the judgments of Supreme Courts discussed in this judgment in detail, the state respondent is directed to publish an advertisement for filling up the vacant post of medical attendant chair, giving options to all eligible candidates. In the said advertisement, the state respondent shall also consider the claim of the present petitioner to get preferential treatment on the basis of land ownership. A mention about such preferential treatment on the basis of land ownership may be made in the advertisement itself. It is also made clear that this judgment would not preclude respondent number 5 from applying to the said post in the terms of advertisement to be issued by respondent state authorities if she is otherwise found eligible Further, as both the petitioner and respondent number 5 have spent substantial period of time in pursuing and defending this present litigation, the state respondent shall consider appropriate relaxation of age in case of the present petitioner and respondent number 5, if they pray for same. With this observation, the writ petition is disposed of. One more is there. WPC 99. In view of the observations made in writ petition number 122K of 19, whereby the appointment of the present writ petitioner was quashed, the petitioner is left with an option to approach the state respondent for payment of remuneration against service which is actually rendered by her. If the present petitioner does so, the respondent number 4 shall verify as to whether the present petitioner has actually rendered any service as medical attendant PHC Chare. And if it is found that she has actually rendered the service, she may be given appropriate remuneration against service so rendered. With this observation, this instant petition is disposed of.
I will read it. I criminal can 2022 and criminal abuse jail 3 or 2020.
For reasons mentioned in the judgment, the conviction of the present appellant under section 6 of the POXO Act is converted into section 8 of the POXO Act, and accordingly sentence is modified from rigorous imprisonment of 10 years with fine of rupees 10,000 in default of payment of fine to undergo simple imprisonment for 1 month to a sentence of rigorous imprisonment of 3 years with fine of rupees 10,000 and in default of payment of fine to undergo simple imprisonment for 1 month under section 8 of the POXO Act. The conviction of the present appellant under section 376(1) of the Indian Penal Code is converted into section 376 clause 2F of the Indian Penal Code. However, the sentence imposed against the said conviction shall remain same. That is, he shall have to undergo rigorous imprisonment for 10 years with a fine of and to pay a fine of rupees 1,000 and in default of payment of fine to undergo simple imprisonment for 1 month. Conviction of the present appellant under section 354A(1) of the Indian Penal Code and the sentence imposed therefore by the learned trial court is not interfered with. All sentences shall run concurrently. With this observation, this criminal appeal is disposed of. The connected IA is accordingly dismissed.
May I please, Your Lordship, Lordship, a bit to mention item number 8 and 9. Lordship, recently the Manpower Rationalization Committee has given its recommendation. So the matter will be placed up before the cabinet. So I pray that sometime may be granted to the respondent, Lordship.
No objection, Lordship. Yes, so. Item number 8 and 9. Mrs. V. Sokri, Lanet, Additional Advocate General Nagaland submits that recently Manpower Rationalization Committee has given its recommendation,
Yes.
which is pending before approval of.
Shortly,
which is-
it will be placed before the cabinet for
which will
approval.
be shortly placed before the cabinet
For
for
approval.
consideration.
For approval,
For
yes.
approval.
Yes. Lordship.
In view of this submission, she prays for listing this this contempt petition after a period of
If your Lordship pleases, after a period of 5 weeks, because it will be placed before the cabinet and we don't know when the cabinet will see.
after a period of 5 weeks. Mr. A. Zo, the Bloomer for Lordship. Mr. W. Marhu, learned counsel for the petitioner does not object to the said prayer, hence the prayer is allowed. Let this case be accordingly fixed after 5 weeks.
Okay, much obliged.
Much.
May I please, Your Lordship, may be pleased to mention item number 1, Your Lordship. It's a part heart matter, Your Lordship, where I was directed to bring the records. Your Lordship, I could not able to get the records, so another 2 weeks will be granted.
In that case, the matter may be released from the party.
Heard Miss
Livika, Your
Livika, learned government advocate representing the state respondents,
Yes.
submits that praise, sorry, praise for 3 weeks time. How much?
2 weeks, Your Lordship.
2 weeks time for placing on, sorry. For placing certain
Documents for-
documents on record. The Mr. Jamir, any submission? Mr. C.T. Jamir appears for respondent number 4. Mr.
And Iran.
L. Iralu, learned counsel for the writ petitioner also does not object to the same. However, considering the fact that this case is considering the fact that this case is listed after will be listed after a period of 2 weeks from now, it is released from the part heard. It shall not be shown as part heard matter in the next cause list.
Your Lordship, I also beg to mention item number 10 on behalf of VG Momi, Your Lordship. I'm mentioning on behalf of VG Momi. Your Lordship, after 3 weeks to file an affidavit, he is appearing on behalf of contendum number 2.
Ms. Libby Khan submitting on behalf of Mr. V. Zimomi, learned government advocate, who is appearing for contender
Contendum number 2.
number 2, prays for 2
3
weeks,
weeks.
3
3
weeks,
weeks.
3 weeks time for filing affidavit in opposition. Ms.
Your Lordship, I'm mentioning on behalf of the counsel for the petitioner. Senti Younger, Your Lordship.
Ms. What's her name?
Conley.
Ms. Conley appearing on behalf of Mr. Santianger, learned counsel for the petitioner, does not object to the said prayer, hence prayer is allowed. Let this matter be accordingly listed after a period of 3 weeks.
Your Lordship, I also have a similar pay for item 13 on behalf of Vijimomi. He's yet to receive instruction. So 3 weeks may be granted. Item 13.
Your Lordship, I'm appearing on behalf of my senior, Moy Jamir.
Ms. Livika submitting on behalf of Mr. V. Zimomi, prays for 3 weeks' time for receiving instructions from the respondents. Ms.
Shisa Jamir.
Sisha Zamir appearing on behalf of her senior
Moy Jamir.
Moa Jamir does not object to the said prayer. This case is accordingly may accordingly be listed after 3 weeks as prayed for.
Your Lordship, I also have a similar pay for item 15 again. On behalf of Vijimomi. He's yet to receive instruction.
Ms. Livika submitting on behalf of V. Zimomi, Landed Public Prosecutor, Nagaland, prays for 3
3
weeks'
weeks.
time for receiving instructions from the state respondent. Mr. Mugaka.
Yes.
Mugaka, Learned Counsel for the petitioner does not object to the said prayer. Hence, the prayer is allowed. Let this matter be listed accordingly after 3 weeks.
Much obliged, Your Lordship.
May it please, Your Lordship. I beg to mention item number 7. Here I'm yet to file affidavit in reply. So kindly grant me 2 weeks time.
Mr. Mugaka, Learned Counsel for the
Petitioner.
petitioner submits that he has received the affidavit in opposition and seeks 2 weeks' time for filing reply against the same. Also, Ms.
Kriki.
Kreki Onu,
Yes, Your Lordship.
Learned Counsel appearing for the state respondent.
Number
You are
4.
Appearing for respondent number 4,
Yes, Your Lordship.
as well as Ms. Livika
For the state.
for the state respondent does not object to this said prayer. Hence, the prayer is allowed. List this matter accordingly after a period of 2 weeks.
Obliged. Please, Your Lordship. I beg to mention item number 2. I may be allowed 3 weeks time to file my affidavit in reply.
Mr.
I Imchen, Your Lordship.
I Imting,
Imchen.
Imchen,
Yes, Your Lordship.
Mr. I Imchen prays for 3 weeks' time for filing affidavit in reply to the affidavit filed by the state respondent. Ms. Livika does not object to the said prayer. Accordingly, the prayer is allowed. Let this matter be listed after a period of 3 weeks.
Much obliged, Your Lordship.
I Imchen.
Perhaps Lordship, I beg to mention item number 22 and 23 on the hearing list.
2 has 22.
22 and 23. I'm mentioning on behalf of my senior Mr. N.K. Luckham, who's leading this case. So let it come up after 3 weeks, Lordship. Some difficulties today.
For reasons,
Lordship, he has a
some
This thing-
difficulty.
he has an injury in his ankle.
Okay.
So it's 3 weeks, Lordship.
Mr. Foseko Fute submitting on behalf of his senior Mr. N.K. Luikam prays for 3 weeks' time on the ground that his senior has sustained injuries.
Lordship.
Ms. Mabeni, Learned Counsel for the appellant does not object to the said prayer. Hence the prayer is allowed. Let this matter be accordingly listed after a period of 3 weeks.
Bless my Lord.
Yeah, please, Your Lordship. I beg to mention item number 20. On behalf of VKO. Taken the consent of the government advocate. Your Lordship.
What is your name?
Atoi Phom.
Mr. Atoi Form submitting on behalf of V. Thanoi, Learned Counsel for the appellant. Praise for
4 weeks, Your Lordship.
adjournment for 4 weeks. He has also taken the consent of
The government.
Yes, Your Lordship, he's taken the consent of
Government.
K. Angami, Your Lordship, PP.
government advocate. Taken the consent of learned public prosecutor. In view of the submissions made by learned counsel, the prayer is allowed. Let this matter be listed accordingly after period of 4 weeks.
Bless you.
Your Lordship, I beg to mention item number 16. On behalf of the state respondents, state is here to file affidavit, Your Lordship, so kindly grant me 3 weeks' time.
Who is for the
Your Lordship, in this matter, I would like to file an additional affidavit. I've recently come into a report submitted by the officer concerned to the directorate in respect of this case, present case. So I seek leave of this honorable court to file an additional affidavit to bring on record later, if Your Lordship may.
no, okay. Miss Apila Sanctum,
AIME,
Miss AIME, submitting on behalf of
state respondents.
state respondents. Praise for 3 weeks' time for filing affidavit in opposition in this case. Mr. Tongpok Pongner also prays for 2 weeks' time, 3 weeks' time for filing an additional affidavit on behalf of the writ petitioners. The prayers are allowed. Let this case be accordingly listed after a period of 3 weeks.
Your Lordship, in the interim may continue.
In the meanwhile, the interim order shall continue till next day.
Lordship.
May I please, Your Lordship? I beg to mention item number 12, Your Lordship. On behalf of the council. Well, there is for respondent number 1, 2, and 3. Your Lordship, 1 week time may be given, Your Lordship.
Who is for the petitioner? You have informed counsel for the petitioner. You have to inform them.
Yes, Lordship,
Miss
Conley.
Conley submitting on behalf of Miss V. There, respondent, learned counsel for respondent number 1, 2, and 3. Praise for
1 week time, Your Lordship.
1 week time for filing. 1 week time. For what reason?
Your Lordship, we haven't received the counter affidavit filed by the government, by the state government.
Contending that they have not yet received the counter affidavit filed by the state government. Learned counsel has also submitted that she will inform about the about her prayer for seeking adjournment to the learned counsel for the petitioner. Considering the grounds shown by learned counsel, the prayer is allowed. Let this matter be accordingly listed after
1 week, Your
1
Lordship.
week.
Your Lordship, I'm also mentioning item number 16 on behalf of the council for,
16.
yes, 16.
16 has already been mentioned. It has been adjourned for 3 weeks.
3 weeks. Okay, oblige, Your Lordship.
Please, Lordship, I beg to mention item number 6, Lordship, on behalf of the counsel for the petitioner, Mr. D. Gogoi, Lordship. I pray that this matter may come up on date 19, Your Lordship, since the counsel is an outstation lawyer from Gauhati, Your Lordship.
Mr. N.
Vero.
Mr. M. Vero
Yes,
submitting on behalf of Mr. D. Gogoi, learned counsel for the petitioner. Praise for fixing this matter on
19/6.
6. Miss
On behalf of K. Angami, PP. I'm standing on behalf of Cameron.
What is your name?
AIME.
Yes. Miss AIME, appearing on behalf of Mr. K. Angami, Learned Government Council. Does not, you have any objection?
No, Your Lordship.
Does not object to said prayer. Hence, let this matter be listed again on 19/6/2023 for admission here.
Lordship, there is an interim. If it can
The
continue.
interim order shall continue till next date.
Yes, Lordship. Okay. Lordship, I can beg to mention item number 11, Your Lordship. Item number 11. On behalf of the council for the petitioner, Mr. PP Paul, Your Lordship. Here we are here to file our affidavit in reply to the affidavit in opposition filed by the state respondent, Your Lordship. So I pray,
Mr. 11,
yes, item number 11, Your Lordship.
Mr. M. Vero, submitting on behalf of Mr. P.B. Paul, Learned Counsel for the writ petitioner. Praise for
3 weeks.
3 weeks' time for filing reply to the affidavit in opposition filed by state respondents. Learned Counsel appearing for state respondent does not object to the said prayer. Hence, prayer is allowed. Let this matter be accordingly listed after 3 weeks.
Lordship, there's an interim here also.
The interim order shall continue till next date.
Lordship. Lordship, I beg to mention item number 18, Your Lordship. Lordship, here, I believe this matter has been fixed. It should have been fixed on date 16, Your Lordship. Though in the order, Your Lordship, it has to come up on after 3 weeks, Lordship, but I believe Your Lordship may remember I made a request to Your Lordship in an MEC appeal that it should have come up on a fixed date, Your Lordship, date 16.
16 June.
Yes,
You are for?
the appellant, Your Lordship.
Otherwise, 3 weeks have also not lapsed.
Yes, Lordship.
Mr. M. Vero, submitting on behalf of for
Appellant, Your Lordship, Tayong Tuba,
Tayang Tuba, Learned Counsel for the
appellant.
appellant, praise for fixing this case on 16th of June.
Yes, Lordship.
Why is fixed date? Why are you praying for a fixed date? Reason?
Lordship, usually in MEC appeals, the returnable date, this date of fixing, it should be on a fixed date, Lordship.
16/6. Who is for the respondent?
There's no respondent, I think, Lordship. We are still servicing notice, yes.
The prayer is allowed. Let this matter be accordingly fixed on 16/6/2023.
Obliged, Madam.
May I please, Your Lordship? Lordship, I beg to mention item 29 on behalf of my seniors. Lordship, the senior counsel, Mr. Yang Gauhati, has some personal difficulties, so I pray that this matter may come up after a week.
Who is for the government? Ms. Desino,
Yes, Lordship.
Ms. Desino Kiso,
Yes, Lordship.
submitting on behalf of her senior younger Bhatti. Praise for an adjournment for
A week.
a week on the ground of
Personal-
difficulty of her senior counsel. Mr. Moa Amchin appearing for
All the respondents.
Learned senior government advocate appearing for all the respondent does not object to the said prayer. Hence, the prayer is allowed. Let this matter be accordingly fixed after a period of 2 weeks.
Lordship.
Obliged.
May I please, Lordship? Lordship, with the consent of the other side, I beg to mention item number 3, 4, and 5. Lordship, the outstation counsel, Sir Ashok Sharaf is indisposed. As such, is unable to appear before his honorable court. Lordship may be kindly pleased to fix the matter on 20th of June.
What is your name?
KV Nagi.
Mr. KV Nagi.
Your Lordship, I want to intervene here. This is a very long pending.
Interim is there.
2020. Now it is 2021. There is an interim. order also when the matter was moved. My learned senior friend, Dr. A.K. Sharif from Gauhati is the leading counsel here. Dr. A.K. Sharif is leading this case.
No,
It's
his
about-
prayer is he is indisposed.
He is indisposed. That is why I'm saying, your lordship, let this matter be come up in early day, not on June 20, because interim is there. Passed in 2020 against the state and represent the state. Now, if my learned senior friend, Dr. A.K. Sharif, is indisposed, then he can come to the VC and we can dispose of them. That is what. June 20 is too far.
Lordship, I was instructed by my senior to,
Interim is continuing since 2020. It's about the Texas matter between the state and the Indian Oil Corporation. Dr. Sharif, my learned senior friend can come through BC on the day fix. Not physical here.
Sir Ashok is also going out of station for some treatment. So Lordship, we kindly please to fix.
20 June is too far, your lordship. Because interim is running since 2020.
Okay. Mr. K.V. Nagi, learned counsel for the writ petitioner, item number 3 to 5. Prays for an adjournment on the ground that learned senior counsel, learned leading, the leading counsel of this case, Mr. A.K. Saraf, learned senior counsel, is indisposed and shall be going out of station for treatment. On the other hand, Mr. Moam Chen, learned senior government counsel, representing all the state respondent, prays for a shorter date for the reason that there is an interim order against the state government.
Running since 2020. Running
Is
since
running
2020.
since year 2020. However, considering the grounds mentioned by the petitioner, the prayer for adjournment is allowed with an observation that all endeavor shall be made to hear this matter on next date fixed, that is 26
2020, sir.
2022. Let this matter be accordingly fixed on 26/2022/23.
Lordship, interim order will be allowed to
The
continue.
interim order shall continue till next day.
Much obliged.
Okay.
Yes.
May I please, your lordship? Your lordship, here the petitioner is seeking for scale of pay. Your lordship, here the petitioner was appointed as a Malay at a fixed pay of ₹750 per month.
Pleadings
Now,
are complete.
yes, your lordship.
State respondent is ready. You're ready. We can hear this matter.
Lordship.
Okay.
Is your lordship may kindly see my annexure 1 at page 9.
Just.
At page 9, your lordship.
This is item number 14. Your name is Toshi Temjen.
Yes, your lordship.
At page,
At page 9, that is annexure 1. This is the initial appointment. Next page 9A for, I've annexed the type copy, your lordship. Yes. Your lordship,
no, 9A is something.
9A, 9A.
Just.
Page 9A. Is your lordship, this is the initial appointment, your lordship. Sherry So of Sitima Village is hereby temporarily appointed as a contingency paid Mali in the office of the So Kefri at a fixed pay of rupees 750. Now, your lordship, it has already enhanced to 5,300, your lordship. Your lordship, here the petitioner.
Yes.
Yes, your lordship, former petitioner, former initial appointment. The petitioner had been serving the department for 18 years. The petitioner had been discharging the same duties as discharged by those grade 4 employees who are enjoying the scale of pay, your lordship. Hence, the petitioner had approached the concerned department for equal pay for equal work. However, your lordship, it was not considered. Therefore, your lordship may kindly see my annexure 2 at page 10, annexure 2. The petitioner had made a representation before the concerned department to at least allow for a scale of pay, as the petitioner had been discharging the same duties as discharged by the grade 4 employees who are enjoying the scale of pay. Now, your lordship may kindly see my annexure 3 at page 12. Your lordship, here in so many similar situated case, the honorable court, this court has also allowed for scale of pay, your lordship. Your lordship, in regard to my submission, I would also like to place one decision which was passed in the division bench. The similar situated matter was appealed before the division bench by the state respondent. However, it was dismissed and then it was directed to grant for the scale of pay, your lordship. Your lordship may kindly see page 16, paragraph 15.
Page
15, paragraph 15,
para 16.
15, 15.
1-5.
Yes, your lordship. I may be allowed to read, your lordship.
Yes.
Furthermore, we are in the respectful agreement and there's no quarrel with the law laid down by the Honorable Apex Court that a question of post interdetermination of pay scale in the primary function of the executive and not in the judiciary. And therefore, the court ordinarily will not embark upon the task of job evaluation, which is generally left to the expert bodies. It is, however, well settled that the principle for equal pay for equal work is applied, where there is a complete and wholesale identity between two groups of employees discharging the same work, and even a daily wage employee who is performing
duties similar to that of the regular employee is at least entitled to receive the minimum skill as paid to the regular employees. In the instant case, the respondent who is serving as a sweeper on contingency basis on a fixed pay of rupees so has satisfactorily discharged her responsibility of explaining that she performed the same work, duties, and responsibilities as discharged by the regular sweeper by making clear averment to that effect, which has not been disclosed by the state appellant. We are therefore of the considered view that the respondent performed the same nature of works and duties as that discharged by regular sweeper, and accordingly entitled to equal pay that is received by the regular sweeper. In view of the decision made above in the law laid down by the Honorable Apex Court in decision, considering all attendant facts and circumstances, we find no infirmity with the order dated so and so passed by the learned single judge in WBC so and so. The state are accordingly directed to carry out the order dated passed by the learned single judge within the period of 60 days from the date of the passing of this order. That's all, Your Worship. So, Your Lordship, there are so many similar situated cases which this Honorable Court has also given a direction to be for the scale of pay. And Lordship, now the petitioner has been serving for more than 18 years.
This writ appeals, the petitioners were sweepers.
Yes, Your Lordship. The petitioner had been discharging the same duties as performed by the forfeit employees, Your Lordship.
Yes, Ms. Chan.
Lordship, I want to rely on my affidavit, Lordship. Paragraph 5, 6, and 7, Lordship.
Yes,
I'm allowed to read, Lordship.
you use micro.
Lordship. That with regard to the statements made in paragraph 5, 6, 7, 8, 10, 11, and 12 of the writ petition, the answering deponent humbly submits being not aware of any representation made by the petitioner for scale of pay. It is not denied that the petitioner was appointed as a Mali on temporary basis. That is to say, the petitioner was appointed without sanction posts. The basis of filing this instant writ petition by the petitioner is seeking this Honorable Court's indulgence for scale of pay. It is pertinent to state herein that the scheme of recruitment regularization under district administration has been subjected of judicial scrutiny in such that 2 cases were filed, that is WPC number 184K of 2016, Bantung Gikon and others versus State of Nagaland and 3 others, and WPC number 97K of 2018, Wetsolo Krome and 5 others versus State of Nagaland and others. The 2 cases were disposed of with the direction to quash Office Memorandum dated 3/11/2015. Page 3, Lordship. However, the court has given liberty to frame guideline rules as deemed appropriate for recruitment of DPs. Accordingly, a new guideline was framed by Office Memorandum number such and such with the approval of PNAR department. Hence, all in-service employees, ex-cadre contingency, casual regularization are being carried out based on the new guidelines streamlined as per the above stated Office Memorandum dated such and such for the next 5 years, with the object to ameliorate and accommodate the in-service employees as per vacancy arising. As such, the argument that the petitioner has suffered injustice and discriminated and has been stepmotherly treated does not hold water, given the fact that her appointment were made without sanction posts. The operative part of Office Memorandum dated such and such is reproduced below. All vacancies arising in the districts shall be filled up on 67:33 basis between the in-service and fresh candidates as per PNR Department OM number such and such. In-service shall refer exclusively to those employees who have been appointed on contract, casual, ex-cadre without sanction posts and who are verified and found to be genuine by the district level verification committee. The concerned TCs should work out the ratio strictly as per the guidelines and submit to the Commissioner, Nagaland, for approval. Para 6, Lordship. The in-service employees will be regularized as per seniority, provided they fulfill all the let down criteria. The proposal for regularization through seniority should be sent to the Commissioner for approval. This will be effective for 5 years from the date of issue of this OM in case
No,
they are
You're reading
Para 6, page 3, Lordship.
of your affidavit.
Lordship. Para 6, page 3.
In page 3, there is no para 6. Affidavit in opposition of state respondents.
Okay. 6. Page 3, para 6, Lordship.
It is in at page 4.
Apology, Lordship.
Affidavit in opposition by the state respondents.
Lordship, my apology, Lordship.
Yes, para 6.
Para 6, page 4, Lordship.
Yes.
That with regard to the amendments made in para 9 of the writ petition, the answering deponent respectfully states that the same are legal submissions, questions of law in nature, and hence the amendments made in the preceding paragraphs may be relied upon at the time of hearing. Be that as it may, it is most respectfully submitted that the apex court in the case of State of Nagaland and others versus Nishivi Achumi, reportable in civil appeal number 4223 of 2022, while dealing with the issue of regularization of service held at paragraph 4.1, that at the time of the death of the deceased employees, he was not entitled to regularization as he was much below in the list of the work charge employees whose services were to be regularized. Under the regularization policy, the services of the work charge employees were required to be regularized as per seniority and as and when the vacancy arises. The services of the work charge employees, even who were senior to the deceased employee, were regularized in the year 2009, that is after the death of the deceased employee. Despite the above, the High Court has directed the state to regularize the services of the deceased employee 1 day prior to his death, which otherwise his service were not required to be regularized as his turn had to come and he was much below in the seniority list. Lordship.
You're done.
Lordship, that's my submission, Lordship.
May I please, Your Lordship? Your Lordship, here
What is the case of Nishivi Achumi? What Supreme?
is, Your Lordship, here the petitioner is bringing only for scale of pay. However, the affidavit in opposition filed by the state respondent, it all relates to a regularization of service, yes. And then even the division bench has also allowed the petition, Your Lordship.
You have to go through. Heard Mr. Toshi Temjin Pongner, learned counsel for the writ petitioner. as well as Ms. Supong Chang, learned counsel representing the state respondents. Hearing complete. Let this matter be fixed again on 2nd of June for judgment.
What's your pleasure?
Orders, I think, 7. Revision are important.
None appears for the petitioner. Item number?
17.
None appears from for the petitioner. It appears from the office note dated 25/5/2023 that by order dated 3/4/2017 this court directed that as the similar matter is pending before Honorable Supreme Court, therefore this matter be listed after disposal of this same. However, from the office note dated 25/5/23, it appears that the status of said case, status of case which is said to be pending before Supreme Court could not be ascertained from the website of the apex court. Stop. In view of the observations made in the office note, the petitioner is directed to furnish the details of the case which is pending before Honorable Supreme Court on the next date fixed. That is not on the next date. Furnish the status of this case pending before Supreme Court within a period of 4 weeks from today. Let this case be listed accordingly after a period of 4 weeks.
Notice, Your Lordship. Notice is still awaited, Your Lordship.
Ms. Supongwati.
Aratsula Caps.
Yes. Ms. R. Atsula Gibbs, learned counsel for the petitioner is present. On perusal of the office note dated 18/4/23, it appears that the notices issued on respondent number 1 to 3 has not yet returned and service is still awaited. Let this case be listed after a period of 4 weeks.
I oblige, my lord.
Supplementary is very important, I think that. Okay, we will begin now.
In hearing list.
Please, your lordship. File a procedural, okay.
Let us,
Yes, yeah.
Mr. Jamir. Page 151, you were at 151.
Yes, your lordship. 151, impugn judgment.
Yes,
I'll read out the judgment, your lordship. The
Just a-
present case was.
just a minute. Yes,
The present case was reverted to the trial court by Honorable High Court by its judgment and order dated 10/7/2017 in first appeal number 1K of 2006, whereby this court was directed to try the case afresh. The brief facts of the case inter alia is that in the year 1975, a dispute arose between Kerativero plaintiff and Wan Sri Putoza regarding ownership/boundary dispute over the Sudan. The dispute was placed before the Office of Political Assistant to the Deputy Commissioner Zukatsa, wherein the parties resolved the dispute through a compromise settlement and the sued land was given to Sri Kerativero. Thereafter, one Sri Ane, younger brother of Sri Dachone and Sri Vechone, filed a civil suit before the Judicial Magistrate Second Class Procedural, claiming that the sued land belongs to him as he has purchased the same from Sri Pungur, elder brother of Sri Kerativero. The same was registered as civil suit number 27, 1976. The Judicial Magistrate Second Class Procedural disposed the same by holding that Sri Kerativero is the owner of the land and imposed a fine of rupees 500 on Sri Pungur for selling the land belonging to his brother and also to refund/return a sum of rupees 1,200 to Sri Anya, 5 order dated 27/9/1977. Thereafter, Sri Muzazo and Sri Anya approached the SDO Civil Procedural on appeal, claiming the ownership of the suit land. The appeal was registered as number so and the same was disposed by Judicial Magistrate Second Class Procedural on 3/4/1979, dismissing the claim. In 1984, Sri Dachone and Sri Vechone Vero filed application before the SDO Civil Procedural, challenging the ownership of Sri Kerativero over the sued land, and the same was registered as number so. The SDO Civil disposed matter on 12/6/1984, rejecting the claim of Sri Dachone and Sri Pechone Vero on the ground that the matter has been settled 4 to 5 years ago. Therefore, it cannot be reopened. Against the order of the SDO Civil Futuro, Sri Dachone and Sri Pechone Vero filed an appeal before ADC and ADM PAC in 1984, which was registered as case number so on 13/11/1984. The ADM PAC passed an order directing the SDO Civil Futuro to retry the case with the direction that no party should cut the land in dispute till the case is settled. The SDO Civil Futuro, by his order dated 13/3/1985, disposed the same by rejecting it on the ground that the same was filed long after the time given for appeal was over. It was at this time that Sri Sanal Kezo, the respondent, came to picture and filed an appeal before the ADC/ADM PAC, claiming ownership of the sued land. The appeal was registered as case number 48/1985, wherein Sri Sanal Kezo prayed for declaring the order dated 31/1/1985 of SDO Civil Futuro as void, and also prayed for declaring him as the rightful owner of the land in dispute. The ADC/ADM PAC, by its order dated 31/1/1985, disposed the appeal, allowing the prayer of the appellant, and thereby declaring the order of the SDO Civil Futuro as void, and further declaring Sri Sanal Kezo as rightful owner of the sued land. Being aggrieved by the judgment of ADC/ADM PAC, Sri Karativero approached the Honorable High Court by filing Civil Revision number 1K of 1986. On 22/6/1990, the High Court set aside the order dated 31/1/1986 of the ADM/ADC PAC passed in case number 48/1985 and remanded the case to the same ADC/ADM for disposal of the same by giving opportunity of being heard to the parties. However, the ADC Judicial PAC, instead of complying with the order of the High Court to dispose the case after giving opportunity of being heard to the parties, passed order directing Sri Karativero to file claim against Sri Dachone and Sri Sanal Kezo, stating the facts, claims, and reliefs within reasonable time. Being aggrieved by the order of ADC Judicial PAC, Sri Karativero once again filed civil revision petition before the High Court, contending that he has no reason to file suit against Sri Sanal Kezo. The civil revision petition was registered as civil revision petition number 2K of 1991. On 3/12/1991, the High Court disposed the civil revision petition by setting aside the order dated 28/11/1990 of ADC Judicial PAC and gave liberty to Sanal Kezo to sue anyone against whom right to sue exists. That, however, Sri Sanal Kezo did not sue anyone and instead started constructing building in the said land, taking advantage of his official position as officer in charge, Futuro Police Station. Being aggrieved, Sri Karativero filed civil revision petition before High Court, praying for intervention to stop the construction. At the same time, he also filed writ petition, praying for appropriate action against Sri Sanal Kezo for misusing his official position. The civil revision was registered as civil revision petition number 13K of 1992, and the writ petition was registered as civil rule number 104K of 1992. While the two petition was pending before the High Court, Sri Sanal Kezo filed application before ADC Judicial PAC praying for early disposal of case number 48/1985, pending before it. The High Court on 29/6/1993 disposed both civil revision number 13K of 1992 and civil rule number 104K of 1992 by a common order, directing the ADC Judicial PAG to treat the petition dated 27/8/1992 filed by Sri Sanil Kesor, praying for disposal of case number 48/1985 as plain, and to issue notice to Sri Gauhati to file written statement and thereafter to frame issues, and call upon the parties to adduce evidence in support of their respective claims, and thereafter hear the parties and dispose the case with speaking order. Thereafter, in compliance with the above order and direction of the Honorable High Court, the parties appeared before this court. However, the entire record case number 48/1985 was found untraceable, as evident from the order dated 9/7/2003 of ADC Judicial PAG. Therefore, both the learned counsels representing the parties filed the brief stories along with their suggested issues. And based on their brief stories and suggested issues, the learned ADC Judicial PAG framed 13 number of issues, and thereafter the parties produced their respective witnesses. And by judgment order dated 28/11/2005, the suit was decided in favor of Sri Gauhati, and being aggrieved by the just said judgment and order, the respondent Sri Sanil Kesor preferred appeal before the Honorable High Court, which was registered as First Appeal number 1K of 2006. And the Honorable High Court, by its judgment and order dated 10/7/2017, disposed the appeal by setting aside the judgment order dated 28/11/2005. The Honorable High Court, while disposing the appeal, observed that to do full justice, the parties must be given a chance of proving their respective case properly. Further, it was observed that the dispute had dragged on for a long time, but it should be better for both the parties and for the ends of justice to have the case tried properly as per law, so that the litigation finally comes to an end. Accordingly, this court was directed to try the case afresh by giving the parties chance to exhibit and prove all the documents which they want to rely on for the respective case, and to allow further examination the witnesses already examined to give further evidence in respect of documents. That upon receipt of the judgment and order of the Honorable High Court dated 28/11/2017, this court issued process to the parties, wherein both the parties appeared through the respective counsels. And in compliance with the direction of the Honorable High Court, this court proceeded with the trial of the case from the stage of evidence. Accordingly, this court issued direction to the parties to submit their list of witnesses whom they wish to examine, and also to furnish any documents the parties are interested to file in this regard. However, none of the parties submitted any fresh documents or introduced new witnesses, but instead conducted further examination of previous witnesses. Respondent produced and further examined RW2 Sri Satahu Tui and Mr. Sanil Kesor deposed himself as RW3, who were cross-examined by the plaintiff. The plaintiff further deposed himself as PW1 and also produced Sri Kutsoye Vero as PW2, who were cross-examined by the defendant, and thus giving full opportunity to the parties and disclosed the evidence. This court, while taking into consideration the issues framed, this court marshaled the evidence of the parties and also examine the records and documents and accordingly dispose the issue wise as under. The following issues were framed for determination in the previous proceedings, which are reproduced here under. 1. Whether the present suit maintainable against the present respondent/petitioner. 2. Whether there is non-gender misgender in the suit. 3. Whether the disputed plot of land was actually sold to the present respondent petitioner. If so, why he was not impleaded as party to the proceeding. 4. Whether the plaintiff's respondent filed a case against GB, Dachone, and Bechone prior to 1969. Whether the present respondent petitioner was disturbed. Why the plaintiff respondent had not initiated action when the disputed plot remained in possession of the respondent petitioner after having purchased the same from GB. Prior to the sale of the disputed land, Sri Dachone and Bechone were the real owner of the land. As such, the present plaintiff respondent has no locus standi. Whether the plot of land prior to impediment of the present respondent as a party is distinct from the present plot in dispute. 9. Whether the present respondent petitioner is entitled to a declaration of title to the disputed land. 10. Who is the real owner of the plot in the present dispute? 11. Whether the construction of an RCC building by Sanel Kiso is in his so-called purchased plot or is it within the share of plot belonging to Retivero? 12. Whether Retivero is common ancestor with Dachone Vero and Vechone Vero of the Vero clan of Ikrama village. Whether the division of the ancestral property, including the disputed land, was affected amicably amongst the inheritors. Issue number 1. Whether the present suit maintainable against the present respondent petitioner. As regards issue number 1, neither of the parties argued in this regard. However, since the suit is proceeded based on the judgment and order of the Honorable High Court, more so, the proceeding has been continuing since 1985 before various forums by way of applications, appeals, revision, appeal, and during such proceeding before various forum, the parties have represented and complied with the orders, particularly last judgment and order dated 10/7/2017. Therefore, the issue in respect of maintainability of the present suit is found affirmative. More so, this issue is required and should have been determined at the initial stage. As such, further discussion on the issue at this belated stage, that too after more than 40 years of litigation, is deemed futile. Issue number 2, whether there is non-gender misgender in the suit. As regards issue number 2, this court has carefully examined the case record, so also the arguments advanced by the parties, but nowhere during the proceeding the parties have raised any claims or objections of non-gender or misgender of necessary parties in the suit. Therefore, in the absence of such claims, objections, or any plea raised by the parties, this court of the considered view that the suit does not suffer from misgender or non-gender of necessary parties. More so, if there exists such issue, it should and would have been settled at the preliminary stage. Issue number 3, whether the disputed plot of land was actually sold to the present respondent petitioner. If so, why he was not impleaded as party to the proceeding. As regards this present issue, though Sanel Kizo has claimed to have purchased the suit land from Sri GB in 1969, with further contention that the suit land was sold to GB by Sri Dachone and Bechone, However, in this regard, there is no documentary evidence exhibited by Mr. Sano Keso to prove his stand. Rather, while going through the declaration, Exhibit A, it reveals that Sano Keso purchased the plot from late Uchozu, wherein he has constructed his house, but the sued land belongs to Mr. Kereti Vero, which is the adjacent to the plot of Mr. Sano Keso. Further, the record reveals that though Sano Keso is claiming to have purchased the sued land in 1969, but there exists a question as to why Sano Keso slept over the matter for about 10 years when dispute over the sued land started in 1975. His plea that he was not aware of the dispute over the land adjacent to his own plot inspires not much confidence worth relying upon. It also reveals from the records that Dachone and Sri Vechone was having dispute with regard to the sued land with Mr. Kerativero, who has filed applications claiming ownership of the sued land before Hesdio Civil in 1984. Whereto, the Mr. Sano Keso was not a party to the said dispute. As such, it gives rise to an inference that Mr. Dachone and Mr. Vechone have not established their ownership over the sued land, and therefore selling of the sued land to Mr. Pirejibi, who in turn sold the sued land to Mr. Sano Keso in 1969, is a contention hard to accept. Further, this court has also taken into consideration of the factum that during proceedings, Mr. Sano Keso has not exhibited any sale deed to substantiate his claim, though Mr. Vechone, while deposing as RW1 in previous proceedings, have testified that sale deed agreement may be there, and Mr. Sano Keso as RW number 3 have categorically testified that sale deed agreement was executed and can be produced as and when necessary. However, no sale deed was produced and exhibited while trying the case afresh again by this court. The only evidence adduced in support of the claim of Mr. Sano Keso are the testimony of RW1, Mr. Vechone, and RW2, Satahu Tunyi. The veracity testimony of RW1, Vechone, is doubtful and unreliable. For the reason that if he and his brother Dachone have sold the land in 1969, why they have filed application claiming ownership in 1984. On the other hand, his brother, Mr. Dachone, has left written document supporting their ownership of Mr. Kereti over the sued land, Exhibit A. The document stood unrebutted. Further, the testimony of RW2, Sri Satahu Tunyi, is merely a narration of incident he observed when he was a child and about 10 years. Even otherwise, assuming the testimony of RW2 to be true, it does not, in my considered opinion, establish the claim of Mr. Sano Keso. In compliance with the order and direction of the Honorable High Court, this court has proceeded from the stage of evidence and accordingly recorded the evidence of the parties. However, while marshalling the evidence, this court does not find any credential evidence to infer that Mr. Sano Keso has ever purchased the sued land, and in the absence of such evidence, this present suit is decided in negative. Further, the dispute prior to 1985, that is, from 1975 to 1985, the dispute was between Mr. Hutoze versus Mr. Kereti Vero, Mr. Anivero, Mr. Kereti Vero, Mr. Anivero versus Mr. Muzazo versus Mr. Kereti Vero, Mr. Dachone and Mr. Dachone versus Mr. Kereti Vero. Issue number 4. whether the respondent filed a case against GB, Dachone and Vechone prior to 1969. Upon perusal of available case records, so also on careful examination of the evidence advanced by the parties, this court nowhere find that there was any litigation against Mr. Dachone, Mr. Vechone, and Mr. GB prior to 1969. On the other hand, the document available on record shows that the suit land was under the occupation of the government till 1972, and the first dispute started in 1975. Further, this court did not find that this issue does not have any implication or force on the present suit for coming to its judicious conclusion. Issue number 5. Whether the present respondent petitioner was disturbed. As regard this issue, the record reveals that prior to 1985, the dispute was between Sri Hutsuze versus Mr. Kerativero, Mr. Anivero versus Mr. Kerativero, Mr. Anivero and Mr. Musacho versus Mr. Kerativero, Mr. Dachone and Mr. Vechone versus Mr. Kerativero. However, Mr. Samuel Kezo, who was a stranger to the dispute, started disturbing Mr. Kerativero by appealing before ADC ADM PAC against the order dated 13/3/1985 passed by SDO Civil Procedural and thereby obtaining order in his favor ex parte. Mr. Samuel Kezo have also further disturbed Mr. Kerativero by constructing building in the suit land, defying the orders and directions of the Honorable High Court. Issue number 6. Why the plaintiff respondent had not initiated action when the disputed plot remained in possession of the respondent petitioner after having purchased the same from PRHB. The evidence adduced by the parties show that the Honorable High Court, while disposing of civil number 2 care of 1991, issued a direction to the extent that Mr. Samuel Kezo is at liberty to sue any party against whom right to sue exists. But as per the report, Mr. Samuel Kezo, instead of approaching the competent authority by way of suit to seek redressal, if any, he started constructing building on the suit land. Further, documents categorically reveals on record that the possession of the suit land was with Mr. Kerativero, as it is evident from the notice issued to Mr. Kerati by Futura Town Council, and this does not in any way bear testimony of possession of the suit land by Mr. Samuel Kezo. On the other hand, this fact also negate the claim over the suit land by Mr. Samuel Kezo since 1969. Further, the several litigation that crop up between Sri Kerativero and other parties also makes me to infer that Mr. Samuel Kezo was not in possession of the suit land. More so, the averment of Mr. Samuel Kezo regarding purchase of the land from Mr. PRHB has also not been proved, in as much as no document has been exhibited or any cogent evidence produced in that regard. Issue number 12. Prior to the sale of the disputed land, Sri Dachone and Vechone were the real owners of the land. As such, the present plaintiff respondent has no legal standing. The present suit is pending between Mr. Kerativero and Mr. Samuel Kezo. Needless to mention that the matter in issue has reached its present position based upon series of litigation before various forums, and the present suit is proceeded based upon the order dated 10/7/2017 passed by the Honorable High Court. And this court, while perusal of records and marshalling the evidence from proper perspective, could observe that Mr. Samuel Kezo has entered into the land while the matter was sub judice before the court of law, and the said Mr. Samuel Kezo has constructed building on the suit land in gross violation of the order of the Honorable High Court instead of filing suit before the competent court. Hence, this court does not incline to deliberate further on the issue of lagastandi, as it may invite multiplicity of cases, resulting in causing injustice to the present suit, the cause of what have been continuing more than 4 decades without yielding positive results. Issue number 8. Whether the plot of land prior to impediment of the present respondent as party is distinct from the present plot in dispute. Numerous litigation from time to time were instituted by the parties before various forums, including the Honorable High Court, wherein the subordinate courts, including the Honorable High Courts in Civil Revision number 13K of 1992 and Civil Rule 174K of 1992, have also come to the conclusion that the subject matter of the present suit is the land where Mr. Samuel Kezo have constructed building in violation of the order of the Honorable High Court. Further, the evidence adduced by the parties does not reveal that the land in question in the present suit is a distinct plot of land and not the present disputed plot of land. Issue number 9. Whether the present respondent petitioner is entitled to a declaration of title to the disputed land. On careful examination of the evidence adduced by the parties, so also on perusal of the available documents in the case record, this court observed that there existed litigation between Mr. Kertivero and Mr. Huchoze, Mr. Anivero and Mr. Kertivero, Mr. Dachone, Mr. Vechone, and Mr. Kertivero over the plot of land, which is the suit land in this present suit. And in all those litigations prior to 1985, there was no mention of Mr. Samuel Kezo, and all the aforesaid cases were disposed in favor of Mr. Kertivero. The record further reveals that while adducing evidence, Mr. Samuel Kezo could not exhibit or has not exhibited any cell deed in support of his claim, except the testimony of RW number 1, Mr. Vechone, who along with his brother, Mr. Dachone, stated to have sold the land in question to Mr. Pirejibi and who thereafter sold to Mr. Samuel Kezo in 1969. However, in that context, an inference can be drawn, which is if Mr. Samuel Kezo had purchased the suit land in 1969, why did Mr. Dachone and Mr. Vechone file application claiming ownership of the suit land in 1985 before SDU Cebu against Mr. Kertivero? This intriguing question still remains unanswered by Mr. Samuel Kezo or Mr. Vechone, RW number 1. Further, the fact that Mr. Ane, who is the brother of Mr. Vechone and Mr. Dachone, have also filed case claiming ownership of the suit land in 1977 against Mr. Kertivero, wherein he claimed that the suit land was sold to him by Mr. Kumur, who is the elder brother of Mr. Kertivero. Depict contradictory testimony. All these facts and circumstances lead to nothing but conclusion of an adverse inference against the claims of Mr. Samuel Kezo. Mr. Samuel Kezo have failed to establish his right over the land as purchaser, adducing evidence, so also placing proper sale deed before this court. And whereas, on the other hand, the evidence and records and observation of various courts in this matter in issue available with this court shows greater and stronger inclination towards the title and ownership of Mr. Kertivero. Therefore, this court cannot declare the title of suit land in favor of Mr. Samuel Kezo. Issue number 10. Who is the real owner of the plot in the present dispute? Since issue number 9 and 10 are of the same circumstances, the discussion in issue number 9 covers this present issue, and as such, both the issues are decided together. Issue number 11, whether the construction of an RCC building by Sanel Kizor is in his so-called purchase plot or is it within the share of plot belonging to Creativero. This issue has been taken into consideration while deciding issue number 8 and number 9 of this present suit. Therefore, further deliberation shall only be repetition of decided issue. Issue number 12, whether Creativero is common ancestor with Dachone Vero and Dachone Vero of the Vero clan of Kikroma village. Although this issue is not a vital issue for determination of the suit at hand. However, since this court has framed this issue, this court discussed the issue as under the evidence adduced by the parties, so also the available records thus nowhere speaks that Mr. Creativera does not share common ancestor with Mr. Dachone and Mr. Vechone of Vero clan of Krama village. Although the witness PW number 2, Mr. Kutsoi Vero, and RW1, Mr. Vechone, have in the deposition stated that Mr. Creativero hails from Trunotsomi clan, while Mr. Dachone and Mr. Vechone belongs to Futsunomi clan. Neither of the witnesses stated that Mr. Creativero does not belong to Vero clan, and as such, in the absence of such negation by the witnesses, the issue stands affirmative. Issue number 13, whether the divisions of the ancestral property, including the disputed land, was affected amicably amongst the inheritors. From the records available before and so also the evidence adduced by the parties, this court observed that the ancestral property of Vero clan was divided by the road between the two subclans, that is Futsunomi clan and Trunosomi clan, and the suit land falls within the portion share of Futsunomi clan. And PW2, Mr. Kutsoi Vero, has stated in his deposition that the person under the occupation of the land prior to division, irrespective of whichever such clan, subclan he belongs, shall continue to retain his ownership, even after the divisions of the land between which was accepted and agreed during the course of division. More so, there is no evidence that the divisions of land was not done amicably. And further, there is no evidence to negate that Mr. Creativero was not in possession of the land in question since before the and after divisions of the land. Thus, in the instant suit, after considering the evidence on record and upon discussion of the issues raised in the present suit, I am of the opinion that Mr. Sanel Kazor have failed to establish his claim over the suit land. Unlike criminal trial, the court in a civil dispute does not search for proof beyond reasonable doubt, but rely on preponderance of evidence. Hence, weighing the evidence produced by the disputing parties in the instant suit, I am of the view to conclude and decide this instant suit in favor of Mr. Creativero, the plaintiff. In the result, the suit is hereby decreed that Mr. Creativero has valid claim over the suit land. Accordingly, this court hereby declares the title of the land in dispute measuring 24 by 12, located opposite SBI Putero branch, Putero town, in favor of Mr. Creativero. And as far as the building constructed on the land in dispute, the party shall abide by the judgment and order dated 29/6/1993 of the Honorable High Court in Civil Division number 13K of K92 and Civil number 104K92, given under my hand and seal of this court, this 17th day of May 2019. Now, your lordship will
Mr.
see.
Iralu, before you proceed.
Yes.
Let us take 5 minutes break. We'll.
Yes.
We'll sit at 12:15.
Yes.
After 5 minutes break, we have to be attentive very. Minutes.
That
Yes.
is the manner in which the trial court has passed the impugned judgment. Now, your lords have seen by reading out that order that there was no discussions on the evidence of the parties. He referred the name of the parties, but who said what, in what manner, which witness said what, those things were not reflected. And without doing that, we cannot say that the evidence have been considered by the trial court. But, Your Lordship, before proceeding further, I may be allowed to make a mention of a slight mistake. In the earlier trial, the respondent hearing examined 3 witnesses, including him 3. And in our petition, mistakenly, we said only 2. Yes, but there are 3. In the earlier case also, in the earlier appeal, we prepare paper book. And in the paper book, the name of the witnesses. First case.
Respondent means Gauhati.
Yes. Witness number 2. In that case, he was witness number 2. Name is Nyi Vero. So there are 3. It is not 2, Your Lordship. I regret the mistake. Now, before proceeding, let me take Your Lordship back to the judgment just read out now. And in paragraph 4, Accordingly, in the fifth line, accordingly, this court issued direction to the parties to submit their list of witnesses whom they wish to examine, and also to furnish any documents the parties are interested to file in this regard. However, none of the parties submitted any fresh documents or introduced new witnesses, but instead conducted further examination of previous witnesses. Now, why I'm referring to this is that now the trial court has asked the parties to furnish documents if they so desire. Now, your lordship knows better. At the trial, now we furnish documents upon which the parties to rely upon. And then those should be examined, whether those are originals or whether those are secondary evidence, or what nature of type, whether it is admissible or not. Now, in the earlier judgment, which has already been set aside, they have not produced any documents, but the trial court referred to some documents which is shown as exhibits, exhibit A like that. And so in the earlier trial, because of those things, because of the examination of the evidence, particularly on documents, has not been properly done. In fact, it has not been done at all in terms of the Evidence Act. The matter was remanded. Now, in the present proceeding, although the parties were asked to produce documents, the respondent here has not produced any documents. He has not. But without producing the documents,
Yes.
in his additional statements, he has marked two documents as Exhibit A and Exhibit B. Therefore, Your Lordship, in this regard, we have to go back to the statement of the respondent, Gauhati. His deposition is at page 100 of this appeal memo. We have given type copies. Yeah. So, type copy was in there. If Your Lordship goes through all these proceedings, Your Lordships will find that there are certain things which are not so regular, be that as it may, since it has been proceeded in this manner, we are helpless. Page 100, Your Lordship.
Typed copies are there.
Yes, we have furnished type copies. Huh? To court. So I would whisper them out. Then which one are we taking this to the court?
Some lines are not legible actually.
Yes, Your Lordship,
But you
there's
can,
some
you may read.
Mary,
you-
Lordship. Yes,
No, you may go to, why are you referring to this?
because in the first statement, he has not exhibited any documents. He has not produced any documents, but
Refer to
Refer
exhibit
to.
A and exhibit B.
now in his additional statements, we will find his additional statements in clear type copy at 104. This is his deposition before the court. additional evidence.
This additional evidence is before, during the trial in which the impugned judgment was passed
Yes,
later on.
yes.
Yes, at page 104. Your submission is
My submission is
that
that,
earlier, in his testimony at page 100,
yes,
he did not produce any document.
he did not produce any document.
But in additional testimony,
Yes,
he referred to
He
two
referred to-
documents as exhibit.
yes.
Where-
And that too, when the court issued notice to produce documents, he
without-
has not produced. But in his statement, he has produced. And that is not the way, Your Lordship. That is not the way to introduce a documents before a trial court. And then the next thing is, now
where-
this,
Yes, you were referring to 104.
yes, 104, this is the additional documents. May I read, Your Lordship?
Yes,
Deposition of witness number with the blue one. Now he's age 86 years. And my name is Creativero. And I'll start from the first paragraph. I am the plaintiff in the present case. I reiterate the statements on oath which was recorded in the.
no, whether Kiriti was the plaintiff.
Yes, he is claiming the plaintiff. He refused earlier and approached the High Court. This is what I'm saying, Your Lordship. Who has made him the plaintiff? And the court has not done its part also, Your Lordship. The court knows
Okay,
in its order, he has referred that I can sue anyone against whom any right to sue exists. And he was asked to file written statement. This is also reflected in the impugned judgment. Despite that, the court has admitted proceeding in this manner. I am the plaintiff in the present case. I reiterate the statements on oath which was recorded in the earlier occasion before the court of NDC.
no, just a minute.
Yes.
In this proceeding, which is again numbered as civil revision 1,
Yes, same.
before district judge Fake,
Yes,
the plaint is the same 27/8/92 petition by the
same.
the petition which was filed by Senyo
Senyo.
on 27/8/92,
Yes,
which was directed to be treated as plain.
plain.
In this case also, that is treated as plain
Yes,
in the instant case
in
also.
this instant case also, because there is no pleading on behalf of the respondent. No written statement, no plain, nothing. Nothing is there. And so, Your Lordship,
No, if the petition of Sanyo
yes,
is treated as plain,
yes.
how Kiriti became plaintiff?
Your Lordship, that is my point, Your Lordship. That's what I'm saying. Even in the earlier case also, I have said that.
Okay,
Now, may I continue, Your Lordship? I am the plaintiff in the present case. I reiterate the statements on oath which was recorded in the earlier occasion before the court of ADC Judicial. Exhibit A is a declaration by Dachone Vero. Exhibit B is a deed of agreement dated 6/10/1994. Inquiry report dated 10/8/1993 is marked as Exhibit C. Now, Exhibit A and B, what are these, Your Lordship? Page. 110. Exhibit A is 110. This is a handwritten document written alleged to have been written by
That's your name.
Dachone Vero on 10/4/84. Now, Your Lordship, this exhibit is not exhibited before the court. It was simply written Exhibit A and produced before the court, which the court has accepted. Now, no original was produced, and there is no signature of the presiding officer, of the trial judge. This is not the writing of the trial judge. No initial is there, nothing. And the date 10/4/84. 10/4/1984.
Yes.
And Your Lordship, translated copy is at page, this is in local dialect. Translated copy is at page. Type copy is at, yes, but 111, translation.
This is in which language?
This is in Chakasan.
Chakasan.
Page 110 is in Chakasan language. Angami, Tengidie. Tengidie. It is in Tengidie.
Spelling?
TENYE DIE.
Any day.
Tengidie.
Okay.
So this is in Tengidie and translated copy is page 111.
Yes.
In Procedural town, an empty plot just near the house of Saneo Dachone, which is in dispute between us with Creativero, shall not be disturbed. An empty plot near my house, Dachone's house, disputes with Creativero shall not be disturbed.
Shall not be
That-
disputed.
Shall not be disputed, sorry. Vechone, Satamu have sold our share to late Putuzu, and Saneo have purchased the said plot from late Putuzu, and at present, Saneo has constructed his residence. Therefore, the small empty plot is truly belongs to Kereti. Hence, I, Dachone Vero, shall not dispute over the matter with Kereti Vero, and I put my thumb impression. Now, left thumb impression of late Dachone Vero. He died in 1918, between 1997 and 98. This Dachone died in 1907 or 98. There's a bureau. There's a B. Type of man. And which is shown as Exhibit B is page 113. This is also in Tengidie. This is dated 6/10/84 and translated copy is at page 114. Deed of agreement dated Kikroma 6 October 84. In Chikri Nasa, a plot between Mr. Sandero and Mr. Vesuru belongs to Kirati, and there is no more dispute. Mr. Kirati have paid rupees 2,600 only to Mr. Vanguyo and Mr. Vakrale. Now, witness Vesunyo and Vesayo Puro. Vengoyo on the right hand side, Kirati. Now, this also has not been produced before the court when notice was issued. And even at the time of the alleged exhibition, this has not been signed by the presiding officer. The original has not been produced, and none of the persons has been examined. Who is the author of this? What does it contain? Nothing is mentioned. There's a zero. There's a C. Page 109. See what he said, C, then what is the one? Where is that? Page? They have not exhibited. Complaint of this one. That's it. I'm sorry, Your Lordship. Now, Annex C said to have been exhibited. Your Lordship, it is now, although he has mentioned Annex C,
Annex C
Annex C, Exhibit C,
at page.
that Annex C copy is not submitted. But that is a complaint lodged by him to the police, alleging that I have misused my.
Where is the Annex C?
No Annex.
Oh, it is not there.
No.
Okay.
And so in our reply, in our exhibits, now after inquiry, I was exonerated. That copy I have annexed as exhibit A. I'm sorry. 2, exhibit 2. But for that, I'll come later on. So, why I'm referring to this paragraph 4 of the impugned judgment is that the trial court issued notice for production of documents. The respondent has not produced any documents, but in his additional evidence, he has produced 3 documents, 2 were annexed, but original has never been produced. None of the parties have been examined. And the trial court also has not tested the veracity, the genuineness of the even the thumb impression of the alleged author of the document. Now, under the section 165 of the Evidence Act,
Yes.
documents must be proved by, it says the word must be proved by primary evidence, which is the original documents. If original documents is lost, misplaced, could not be found, or in somebody's possession, then the person who is relying on the document has to say those things in order to admit the primary, secondary evidence. Now, in this case, nothing of the nature was done, but blindly, the trial court has fully relied on this Exhibit A, the so-called Exhibit A. And in fact, Your Lordship, allow me to mention that at this stage, now we also have a next document, but we did in the same manner. And although we have not objected to at the time of submission of these documents, now prior copies were not given to us in respect of both the parties, but that does not absolve the responsibility of the parties from proving the contents of the documents in terms of the Evidence Act. And even though a party may not object to the production of a document at the trial, its admissibility is still can be raised even at the appellate stage. And it is the bounden duty of the court, of the trial court, to see whether these documents are being exhibited or produced in a manner as prescribed by the law. That has not been done. On the other hand, if the court wants to rely in this type of documents, now the same yardstick and the same principle should be applied to the documents of the other party. Same. But in the present case, the trial court has completely closed its eye to the evidence documents of the appellant. And the trial court relied upon an inadmissible document which has not been proved, as if that is, this document is the gospel truth. The court has not done its duty. That is one, Your Lordship. Then
the points which you are pressing, the main points which are pressing, like admissibility of
yes, of documents.
documents, can you give me later on the in a written form, in bullets point, your contentions?
Yes.
In one sheet of paper.
Yes. Yes.
I request both the parties.
Yes. Yes. And we'll give citations also. We have
Okay.
yes.
Otherwise, in addition to citations which you are relying upon, because certain dates are important,
Yes.
certain exhibits are important,
Yes.
and your submissions on those, like exhibit A and exhibit B, your submission is exhibit A and exhibit B
Yes.
were not properly exhibited.
Yes.
Originals were not called
Produced.
for,
Yes.
and though it was not objected to by you at the time of trial, you can
Yeah.
raise this plea of admissibility at appellate stage also.
Yes.
These things in bullet points I want.
Your Lordship. Your Lordship. And let me continue with the additional deposition of the respondent.
Yes.
Second
Page
paragraph.
104.
Yes. Oh, no, 94. In the second paragraph, we were claim.
Page 94.
No, I'm sorry, Your Lordship. It should have been
Additional is 104.
104. Now in cross, Your Lordship. Exhibit A stated that Vero, Satamu have sold our share to late Huchozu and Sandao, and the small empty plot belongs to Kirati. I have found the date appended exhibit B1 of the witness. He is made to understand the sum of rupees 2,600 has been paid to one Mr. Vongoyo and one of the witness is Vesayo Puro. The other name of the witness is Niryo. It is signed on 6/10/1984. Deed of Agreement Exhibit B. I have further submitted Exhibit C also. I also have heard that an order issued by the DGP on 10/4/1997 has been made known to me. I also agree that during 1995, the then PADDC Kuhucho has apportioned the land between Hutozo and myself. It is also a fact that a small portion opposite to the post office was given in favor of Kereti. It is a fact by the order passed dated 27/9/1977 in connection with civil suit case 2776, wherein A. Dogra passed the order, Sri Ane and Sri Muzato was not present. I cannot make further comment on the observation made by the second-class magistrate Sri A. Dogra before 1975. All the verdict was one. If the division of the land was after 1975, the small plot of land which I am claiming was that small plot of land in question prior to 1975. The portion of land belongs to me. However, since Dachone and Bechone pestered me in relation to small plot, I compensate them in relation to the small plot in dispute that I have paid Dachone and Bechone a sum of 1,000 each, and they have assisted me in cutting the plot. I have also given to Bong Yuyo and Bakralas Ania's wife a sum of 2,600 for Ania's grave construction. The sum of rupees 2,600 was not for payment of land, but was a token assistance for construction of grave. One of my witness name is Kutsuyo. I do not know who is Nyevero. Business name. Now this is his second witness. His second witness. He is not my witness in any of my case. It is a fact that Kutsuyo Vero is my witness. It is a fact that the statement made by Kutsuyo Vero is a statement given to my credential and support. It is a fact that the division of land has been made between Futsunomi and Kunotomi clan. I also admit it is a fact that the Kunotomi does not have land above the road. I do not know whether Pire is a GB or not. The post office was located towards the road, which leads up to K-Terre residence from the police point. I have not heard the order dated 13/11/1984 passed by Sri Hang Sin. Besides having pursued with the matter since 1/9/1975, the order of Hang Sin came to light only in 31/1/1986. Umar is not my witness, and the submission of Nyevero was done behind my knowledge, and for that statement is closed thereof in respect of Nyevero. Re-examination. In the deed agreement dated 6/10/1984, there were two witnesses, namely Niryo and Vesayo Puro. That is the contents of the deed of agreement. It has been stated that there is no more dispute against Sri Kereti. It is stated that there was an agreement between Futsunomi and Kunotomi clan. Kunotomi clan land is above the road and Kunotomi land is below the road. Now, at this point, the dispute land is above the road. It is further stated, if any person belonging to Kunotomi clan has cleared any land belonging to Futsonomi, then as per the agreement, the land will belong to him. Likewise, if any person belonging to Futsonomi clan has cleared the land of Funosomi prior to agreement, the present has cleared the prior to agreement. The present disputed land is located opposite SBI and not SBI. So that is his additional statement. Now, Your Lordship, what is his first statement? Although we have not prepared type copy for this, I may be allowed to read out, Your Lordship.
At page,
At page 100. This is
yes.
I am the plaintiff in the present land dispute. There is a Chikrinasa colony at Puchero town, and that whole plot of land belongs to clan of Veros of Kikrama village. Long time back, the Department of Health and Family Welfare requested our clan for donating land for construction of a dispensary and other staff's quarters. And we have contributed our land to the government. And the concerned department have also constructed dispensary and other staff quarters. But since there were vacant land in the said area, I requested the concerned department to buy back all dispensary by me. While applying to buy back this old dispensary building with
GBs.
all the GBs of my village, being aware that I own the land where the old dispensary building stands, recorded my case, including the then EAC Puchero documents available on record. In the meantime, let Kuzozo allege that he had already purchased. So this is his statement in chief. He says he's the owner. He wants to buy it back, but there was no evidence that he's the owner or that he was allowed to buy it back. These are all allegations, mere contentions without proof of it. And the thing is, now, he has not filed his written statement. That is why one of the grounds of this appeal is that when no written statement is filed by the respondent, at any stage, he can say whatever he wants to, because he cannot, no written statement is there. Whether he is denying, whether he is admitting the statements, averments made in the plaint. Therefore, he has been given all the opportunities to state anything what he wants at any stage. If he filed the written statement, that would have been prevented. That would have been prevented. Despite that, now certain averments made by him during the examination chief as well as in cross, we'll see a lot of discrepancies, contradictions. And that when we see the statements of his own witnesses, we'll see that also. Now in earlier, his witness number 3, witness number 2, and to which he denies that Nye Yevero is not his witness. That witness stated that Gauhati purchased the land from Dachone and Vechone in 1984. He is on witness. Because of that, now in his additional evidence, he is denying that he is not my witness. Whereas in the book list earlier prepared, he is number 2. Nye Vero is number 2. This type of tactics he is resorting to. And as I said earlier also, now I forget one of. And as far as division of the land is concerned between Funosomi and Fusunomi, there is no dispute about that.
Two
It
different
is that,
plans.
yes. And if your lordship goes by the evidence, now that was divided maybe sometime in, there is no written record and nobody could exactly remember, but it was before, immediately after the death of our eldest brother. I'm sorry, the eldest brother of Dachone, Vechone, and Anye. There are 4 brothers. So this eldest brother died in 1962. And immediately after some time of his death, this division took place. And it was much, many years ahead of the 1969. And now in issue number 3, the court says page 158, issue number 3. Whether the dispute plot of land was actually sold to the present respondent petitioner. Your lordship, when we read this, I got always confused. Who is the respondent petitioner?
He is speaking about Senyo or Kireti.
Yes, I have not been able to actually, I'm not clear. With that as it may. If so, why he was not included as party to the proceeding? As regards this present issue, though Sanyo Keso has claimed to have purchased the sued land from Mr. Pire GB in 69, with further contention that the sued land was sold to Pire GB by Dachone and Vechone. However, in this regard, there is no documentary evidence exhibited by Mr. Sanyo Keso to prove his stand. Rather, while going through the declaration, Exhibit A, it reveals that Sanyo Keso purchased the plot of land from late Putozo, wherein he has constructed his house. But the sued land belongs to Mr. Kereti Vero, which is adjacent to the plot of Mr. Sanyo Keso. Further, the records reveals that though Sanyo Keso is claiming to have purchased the sued land in 1969, but there exceeds a question as to why Sanyo Keso slept over the matter for about 10 years when the dispute over the land started in 1975. His plea that he was not aware of the dispute over the land adjacent to his own plot inspired not much confidence relying upon. It reveals that the records of Sri Dachone and Vechone was having dispute with regard to the Sudan with Creativero, who has filed application claiming ownership of the Sudan before SDO Civil in 84. Now, Your Lordship, in 84, perhaps 84, there was a small vacant plot of land which I purchased from the GBP rent. Just beside that one, a footstep goes up. And in 84, he cut a small portion of that area in 84. And because of that, now I came into the picture in 84. Before 84, nothing. Despite so many illegal orders passed by the various forums, in which no identification of the so-called disputed land was shown. Only in 84, he tried to encroach my land. From there, this matter started. I came into the picture.
Who tried
Then-
to encroach? Kiriti.
Kireti, by cutting a small portion of the earth on the vacant land. Now, although at this point of time, when evidence was taken, no, that's unreliable. Somehow said unreliable, not trustworthy. So, where is the question of 10 years sleeping over my right? And when I'm not a party in the suit, and when it is in my possession, if there's any dispute between two parties, without me, any order passed in those cases will not affect me. Will not affect me. But the trial court, this is the understanding of the trial court. Without application of mind, without the application of its judicious mind, blindly, the trial court has accepted the versions, the illegal orders passed by various firms in favor of the respondent. Now, although
When you came to picture,
84, because he cut a portion of the land near that footpath going up from the main road. And because of that, as he stated in his statement, the town committee of Futsarton stopped him, saying that you are encroaching the public footpath, the public land, road. Now, Your Lordship, although I have not produced in spite of claiming that I have purchased the land in 1969 from period GB. Now, my witness, one of my witness and one of the seller testified when he was alive that I purchased the land from so and so. Now, proposed statement. Person was on here. Directive statement. Number 5,
You first approach SDO
no,
for sale in 84.
no. ADC, ADM. Pack.
No, but that at page 24. 24 of the paper book,
24.
24,
Petition.
yes.
Appeal memo.
Or Dachene and Vichoni, they approached.
Yes.
Now my query is, when you first approached in this litigation, when you for the, earlier you
84.
were not party.
No, never.
So when you first came to the picture in
84.
this series of litigation,
84.
84,
84. I approached ADM Pack, and Hansing. He was then ADM Pack. And he issued the order setting aside the orders passed by EAC, SDOs, but on appeal, on the revision petition filed by the
or
respondent,
enhancing.
that was quashed.
Okay.
Now, despite the fact that I have not been able to produce the sale deed earlier during trial, a person who is living, one of the seller, deposed. What's the matter? Which one? '89. This is my witness number 1.
Page,
Page
page
89. So statement as well. This deposition was recorded sometime in 2003. He is witness number 1.
yes.
And this statement was given
Who
before
is
the
he?
Lordship.
Who is he? Vichoni?
Vechone.
Vichoni.
Yes. And this was deposed in 2003 before the ADCJ Peg Sri Khape Goza on 30 September 2003. My Lordship. I know this case is between Saneo and Kirati, and for that I'm standing as a witness for Saneo. The dispute is pertaining to a plot of land at Fuchera town. I'm from Kukrama village. We have our plot of land at Fuchera town. Our plot of land is above Bible College Road to Mission High School Junction. The land below the road is owned by Kirati Vero. We have divided our land, and it is according to what I have mentioned as of now. I belong Fuchunumi clan, and Kirati belongs to Trunusumi clan. The plot which Sanel is in occupation as of now belongs to us, which sold to Pire GB, who later on sold to Sanel Kezo, the respondent in the present suit. The land which was divided between Fuchunumi and Trunusumi clan has been divided since last 30 years and above. This particular plot in dispute is sold to Pire by me, Vechone and Dachone. We have no claim over the land below the road, which is owned by Kirativero, appellant petitioner, but the land situated above the road is solely over ours, and there is no claim of Kirati above the road, which belongs to us, now owned by Seneo Gezo, defendant petitioner. We are the real owner, and there is no other parties to claim over land in the present disputed site. The construction of RCC building by Seneo belongs to us, Funutsumi, and not by Funutsumi clan. The distance between Zukata and Fuchero could be approximately 10 kilometers. In cross, Yakucho, Dachone, Vechone, and Ane are brothers belonging to the same clan of Futsunumi. I and my elder brother, Dachone, sold this plot to one Pirajibi, but I could not remember the actual date and year. Those days, the land are not that expensive, and I believe we have sold for considerate amount of rupees 150. 450, I'm sorry, 450 only. Sale deed agreement may be there, but it is not in my possession. There is a witness by name late Sukrusu, who died long ago. Futsunumi clan and Funotsumi clan are all of Vero's clan of Kikrama village. Land division between the Futsunumi clan and Kunutsumi clan Vero, I am not in a position to ascertain the exact year, but division took place after the death of my elder brother Yikucho. Yikucho died between sometime in 77 or 70. Oh, no, I'm sorry. Yikucho died in 1962. I'm sorry. At present, no Futsunumi clan resides below the road. At present, Sanoi Kezo is having two houses above the road, which includes the present plot disputed of the land. One land was sold to GB Pire. Nothing is connected with Tereti Vero. Now, this is my witness statement, the seller. In prose, nothing is rebutted. And he was examined before the then ADCJ Kapekosa in 2003. 19 May. Or just meant 19 May, 2019. Yeah.
So it's a time.
We'll meet at 2. We'll break for. Normal break.
Yes,
At 2, we'll again meet.
Your Lordship.
How long will be your submission? How
Your
more?
Lordship, since in view of the impugned judgment, I need to refer to the
Yes, but it would
evidence.
be helpful for me if you give bullet points of your submission,
Your Lordship.
because we have
Very limited time.
limited time,
Yes.
2 more days, and it is going very long. It is complicated also.
Yes,
You have to make it simple.
yes. What happened is that without knowing the past histories, the court simply reflects those and come to their conclusion. Since he has been given that, and in that year, he has been again given ownership without examining.
Okay, we will continue. And
Your Lordship.
Yeah, what chapter is that?
We'll just mention for next one. Jelas expression, personal reference. This is
Haven't bring that. You might have a brand.
May I please, Your Lordship. I beg to mention hearing item number 21 on behalf of my senior Moaz Amir, counsel for the petitioner. Lordship, he has some personal difficulties to take up the matter today, so kindly list it on, fix it on the 6th of this month, Tuesday,
Item number,
21 one.
okay. Mr.
Manhe Konyak.
Manhe Konyak submitting on behalf of his senior Moajamir. Praise for listing this case on 6th of June. 6th of June. No objection.
I'm revealing the state here, Your Lordship.
Mr. Moa Imchen, learned senior government counsel representing the state, does not object to the said prayer, hence list this case for hearing on 6th of June.
Deeply obliged.
Yes.
May I please, your lordship. My lord, we may be allowed to submit the type copies which your lordship has directed yesterday.
This is type copy of annexure 7.
Yes.
I was 7, 8. 7 and 8. Yes, madam. Yes.
Your lordship, I have just read out the the position of my witness RW1.
Bechone.
Bechone, yes. Now, the in cross, the respondent has not been able to rebut the statement of
He
his
was not
witness.
cross-examined.
He was cross-examined at page 90. This is his cross-examination.
Oh, yes.
Then now the in view of this, now the impugn order, what the trial court said about this at page 15. Nine, 3. $59. Now, the impugn judgment at page 160. The trial court said the veracity in the second line.
Yes.
The veracity testimony of RW1 Bechone is doubtful and unreliable for the reason that if he and his brother Dachone have sold the land in 1969
why they have filed application claiming ownership in 1984. This. Now, the reason given by the trial court is that if they have filed, they have sold the land in 1969, then why did they file case application claiming ownership in 1984? Why? Now only in 1984, the respondent started digging the earth. And since I have purchased the original landowners are Dachone and Vechone, they lost the complaint against him, saying that we are the owners, because the original landowners, the seller, is always a necessary party. And if necessary, they have to file complaint. And so I'm a purchaser. And so I also can file a complaint against the seller, which I did in my claim in 1992. But this is the reason. This simplifies, this indicates that there is no application of mine of the trial court at all. There is no reason. And doubtful and unreliable.
No, if the land was already sold to Senyo
Yes.
by Dachene and Richone
Yes.
in 1969.
Yes. Now, why did they claim in 1984?
84, because
That
they have already sold it.
They have already sold it. But I also complained against them in my petition, treated to be as plain. I have fought against them also. Their name also is there. And against Kirati. And so in turn, they also complained against Kirati because original landowners are they. So there is nothing wrong in that. But without understanding that, the trial court has reflected in this manner. And doubtful and unreliable. This is a demeanor of the witness. Whereas this trial judge has never had the opportunity to examine the witness. This was in 2017. Witness was examined in 2003 before the then ADC Kapekosa. The trial court failed to understand if a dispute arose, who should complain and who should be mid-party. That is the reason why this he has mistaken. And then in the next slide, the sued land Exhibit A, the document of the respondent, stood unrebutted. There is no application of mine at all. Now, the Exhibit A, let me repeat again. Page. Exhibit A.
At page 100.
Hundred and 10. English is 111. Now here, assuming, let us just simply assume
although these are not admissible nor proved, the documents does not prove itself. Now this is in 1984. What was the consideration? What was the consideration for this? Assuming that this is a valid one. Then the respondent's own statement says he paid ₹1,000 each to late Dachone and Vechone. And he got the land. Then again, he paid ₹2,600 to the wife of Anya, late Anya, and the son of the eldest brother, Yukucho, 2,600. But at one point of time, he said again that this is not for the land, but this is for the construction of the grave. Which one do we take? And if this land, this particular plot of land was ordered in his favor in 1975, for the last 11 years, what was he doing? Why he purchased only in 1984 from Dachone and Dachone again? He claimed ownership in his deposition first. He is the owner. Now, that plot of land was during those days, lands for government development was mostly on donation, free of cost. We don't pay, we don't claim compensation. Mostly free of cost. Now, if the land was given free of cost, why he is asking to buy back the land if it is his own land? I do not buy back my own land, but the medical department vacated that dispensary. And of course, later on also in the miscellaneous application IA, it will come. But now what is his claim? What is his stand? Firstly, in 1975, although I do not go back to 75, what was, on what basis he got which land? On what basis which land was settled by Yukucho. And subsequently, the subsequent developments from forum to forum, which land was decided. Then for which land, the respondent paid ₹1,000 each to late Dachone and late Vechone. Then he said he has paid ₹2,600 to the wife of late Anya, our brother, the brother of late Dachone and Vechone, and the eldest son of Dachone's brother, Kucho, who died in 1962. And where is the connection of that one? Which one? What is his stand? So the consideration of the trial court is mischievous. It is very mischievous. So now what is Exhibit A? Much reliance is made on Exhibit A. And so if this Exhibit A goes, there is no case for the plaintiff. If this Exhibit A cannot be exhibited or cannot be admitted or is not proved.
Exhibit A is, what is it? Is it a certificate?
This is a.
Or a statement of Dachone?
No, this This is the a sort of certificate by late Dutch owner Vero. Original was never produced. And under what circumstances, on what consideration this was made, nothing is shown. And it was under the thumb impression of late Dutch owner. He cannot be called and examined, but the veracity, the authenticity of his thumb impression has to be proved by producing the original, because there will be a disputed question of facts. And then similarly, the agreement, which is Exhibit B, as I said earlier, same, no original was produced. And therefore, if these documents cannot be admitted in this manner, then no case is there in favor of the respondent. In short, that this can be the outcome of this writ appeal and the impugned judgment. Because documents, that is the most important. Even though I have not produced documents. Now, if these documents is to be treated as genuine or as proof, then this has to be proved in the manner as prescribed by law. Then the trial court also has referred to a notice. Notice issued by at page 162, while dealing with issue number 6. Page 162. In the second line, further, first sentence, further, the documents categorically reveals on record that the possession of the student was with Mr. Keretivero, as it is evident from the notice issued to Mr. Kereti by Futura Town Council, and this does not in any way bear testimony of possession of the student by Mr. Samuel Kezo. Now, this notice, so-called notice, where is it?
Not exhibit.
It is not a part of the record. No date is also even mentioned. So if this goes, because by the trial court tries to establish the case of the respondent by relying on this. So in fact, even without going further, if these things cannot be rebutted, then the impugned order goes. Then the court also has a biased mind. Because it is true that the order of the High Courts in civil revision brought by the respondent reveals actually that although I've been asked to file my plain within 2 months, I failed. And only in 1992, I filed the order. I filed the plain. Subsequently, the High Court, without giving any further observation, said this is to be treated as the plain. Now, what did the trial court did? The trial court jumped on me, saying, without filing the plain. he is now totally against me. Without further proceeding, despite the fact that I have not filed the claim within time, the High Court has allowed it. So why not consider those things? So the trial court has a biased mind. Then the discussion of the evidence, story-wise, yes, he has narrated some stories, but when the evidence is discussed, it has to be discussed which witness says what, and which witnesses statement deals with which issues. Those things have to be a part of the judgment. If no evidence were discussed, the judgment will be no judgment at all. There will be no judgment at all without discussing the evidence. Then, if at all, although we have committed the same mistake on the part of the appellant, they do not be fatal to me, because like the handwriting, 107. Now, Your Lordship, at page 107, we cannot hide our own mistake.
Ungoro.
Humor. Now, this is a statement by Humor. Translated copy is 107. While exhibiting this one as exhibit, we have not produced the original also. The other party has not objected. So we have committed the same mistake. But my point is, if the trial court desires to rely much on exhibit A and exhibit B, which was similarly shown as exhibit, like exhibit 1 of the present appellant, this should be considered in the same, with the same weightage. Same weightage should be given. Similar treatment should be given, but this wasn't considered at all. And what does it say? This is the elder brother of the brother of the respondent, and he himself denies the titleship of that Gauhati over the present disputed land. Why did not the trial court refer to this one? If this is not reliable, he can give you reasons on the basis of the evidence adduced by the parties, not his own reasonings, not his own reasonings. He cannot presume to reject a document. It has to be based on law or rule, not on presumption, not or assumption that because of that, this is not reliable, doubtful. But he has not considered this at all, nowhere, not discussed. Let my evidence be rejected, but consider it and discuss it and reject it. If it is to be accepted, discuss it, reflect it in the order sheet. For what reason this evidence is not acceptable? Let him give reasons on the basis of the records, not on the basis of his whims. The court has a duty to find out the truth, which the Honorable Supreme Court has very wisely narrated the functions of, especially the trial courts. The trial court has miserably failed to exercise its jurisdiction vested in it. But there is this impingement, so there is vested interest in this, in this case. The past is gone. The past is gone. And how many times a person wins in the lower courts will not establish the title of a person until his title is proved in accordance with law. How many times I lost? It doesn't mean that I'm entitled to a title when I establish that title. Doesn't matter how long it takes. We say justice delayed is justice denied. But justice hurried can be justice denied equally. Same. So let it be 45 years. There are some cases more than 100 years. Even in Dimapur case, during those days, Raja case, it lasted many years. So that thing should not, those things, when we come to those things, everybody becomes emotional. Everybody becomes emotional, including some courts, not this court, Your Lordship. Please do not misunderstand. Why this has been pending for such a long time? Why dispose it of immediately? One should not become emotional like that. One has to see the backgrounds of the case. What happened? Now the backgrounds of the people. Without considering those, a case taking so many years, with ups and downs, without proper evidence, without proper trial, we cannot simply brush aside that, yes, it has taken so many years, and in all those cases, the order has been in your favor, so it should be in your favor. That is not the case, Your Lordship, and that cannot be the case. Every party has to prove his case by evidence. And so, although if I'm to continue, since it will take much longer, and since we are going to submit our bullet points of our arguments, I would like to shorten it. Now, but I cannot, at the same time, I cannot forgo my statements, my depositions. Page. Sano deposition. '93. Let me read my deposition. Page 93. We have not given any additional
Evidence before this.
no, we have given additional customer.
Yes.
Yes, we have given legal. From the beginning, I'll read the Lordship. Page 93. My name is Sanil Kazo, and I'm the respondent in case number so. This case pertaining to a land dispute at Zero. This land of mine was sold by Vechonevero and Dachonevero to GB Pire, and I bought this land from GB Pire during the year 1969. I am now in possession of the same and also has constructed my house over the purchased land. Since after a long time, Kirativero claimed the said land, which I'm in possession. The land which you bought from Dachshund Vetchune is mine. And for that, I lodged a complaint against Dachshund and Vetchune Vero. And Dachshund and Vetchune and PRGB came to the court and have clarified to the court, saying that we have sold plot to GB Pire, and that which Sano now occupation does not belong to Kiriti. This was before the court of ADC ADM Pact, and that the court has decreed the land to me as it has been clarified to the court by Dachshund, Vetchune and PRGB, that after a long gap, Kiriti filed a case against me into High Court Kohima. The Honorable High Court has redirected the case to the ADCJ Pact. Then ADCJ has summoned us to this court, and Kiriti also has attended the court on the day, and ADCJ has written an order to Kiriti, and the said order has been given asking Kiriti to file a case against whom he wished to his court. Kiriti, instead of filing with the ADCJ court, has appealed to the High Court Kohima. Then after that, High Court has redirected the case to ADCJ Pact to decide upon the issue of the land dispute, which is still pending. That the question of land dispute in the instant case has been given his earlier brother by name Bungor Vero, declaring that this disputed land does not belong to us and also does not belong to Kiriti also. Bungor, he stated that the land at Fuchero Town, demarcating from Mission High School to Government High School main road is the boundary. Bungor stated that the Kunutomi clan and our land are below the main road, which has been indicated earlier, and above the main road belongs to Kuchonomi clan. This land which I am in possession is above the road and is in the land of Kuchonomi clan. And that the owner of this land belongs to Dachshund and Vetchune, who are from Kuchonomi clan, and this all has been stated by Bungor. And Bungor has acknowledged the fact that Dachshund and Vetchune sold to GB Pire and GB Pire sold to Sanyo, and it's clear that this land belongs to Sanyo. And Bungor has affirmed that his words are true, and these words have been written by Chikrinasa Colony Chairman Mr. Rasuboi Gezo. Document dated 15/12/1990, submitted to this honorable court as Exhibit 1. And for all these reasons, I pray to the court to pass a decree restraining Kiriti over my property henceforth. I'll furnish the relevant documents at the time of hearing. In cross-examination, in 1969, December 5th, I knew that Vetchune and Dachshund had sold the plot to GB Pire. I purchased the plot from GB Pire on 15 December 1969. I have sale agreement exhibited between our two parties, which can be produced before this honorable court as and when necessary. On 31st January 1985, I came before the ADC ADM Pact court, and the matter was settled in my favor. At the time of Kiriti elder brother Moore's statement, when it was recorded, Mr. Kiriti was not present. At the time of Moore's statement, recording Mr. Sanyo Kezo, Mr. Raju Boyo Kezo, and Mr. Pumur Vero were only present. With regards to land division between two subclans Veros, no specific year was stated or mentioned by Pumur. And in the additional statement, page 95,
My case before the police has been settled and revoked. Exhibit 2 is the order from DGP Nagaland dated 10/4/1997. My previous statement, which has been recorded, I reiterated the same. In cross-examination, I'm not aware about the dispute arose between Kiritivero and Hutozo in the year 1975 over the suit land. It is true that prior to 1985, I have not filed any case against anybody over the suit land. It is true that after the direction given by the Honorable High Court by order dated 3/12/1991, was in Civil Revision number 2K of 2017. I have not filed any case against anybody. It is correct to say that I have constructed the building over the suit land. However, I'm not so sure about the year when the building was constructed, but it might be after 1985. I have constructed the building without the direction of any court. It is true that over the construction of the said suit building, there was a dispute between Saneo Kezo and Kiriti Vero, and to that effect, Kiriti Vero has filed complaint against me, and there was an inquiry from the police. In re-examination, Your Lordship, I don't build my houses with court order. There is no hard and fast rules to obtain a court order to construct building which belongs to me. Your Lordship, this answer is very unwise, but depending on the question put to him, maybe he has given this answer. Otherwise, this answer is not wise. With apology, I say that. So that is my deposition. And the witness number. The next, my witness number 1 is Kutsoyo at page 96. Additional stipend taken. Yes. This is my witness statement. Page 96. The dispute between Saneo Kezo and Kiritivero, as far as I knew, the plot belongs to Kiritivero. No? No, this is the witness of the defendant, the respondent.
Kutsoyo, the person with whom any had case in 1976, same person. After the 75 compromise,
Yes.
there was a case in 1976 between Inni
Yes.
and Kutsoyo.
Muzazo.
It is
Kutsoyo is different.
okay.
Yes. But this is a respondent's witness. My witness 91. Satahi.
Kutsoyo is your witness.
No, Kutsoyo is
Respondent's witness number
respondent's
1.
witness. Yes. And page 91, Satahu Tungi is my witness. They go to Motodoza. Mary Lordship.
Yes.
I know this case between Saneo case pertains to Saneo and Kiriti, and for which I'm called as a witness for Saneo. This case pertains to a plot of land and situated at Procedural town. I know that there was a land belonging to us at Procedural town, owned by my father. This plot of land was sold to Saneo Kezo
The land was sold by my father to Saneo Kezo. I'm not aware as to how this plot of land bought by my father, and also do not remember the year when it was sold to Saneo, as I was a child then. I'm very much aware of the fact that present disputed plot of land belongs to us. I know since my father told me, and also has clarified myself. The present disputed plot is above the road and is above the main town road. This plot is situated above towards Chikri Nasa Road. The present disputed plot is situated near Police Point and is situated opposite to the State Bank of India. And this SBI is below the road. I know that Saneo has been in occupation on the above disputed plot since very long. In cross-examination, I am son of late Pire GB. Now he's the son of late Pire GB. He passed away in the month of 1993. Saneo at present have 2 houses at Chikri Nasa, colony of Visero town. At the time of transaction of plot by my father, late Pire GB, to Saneo Kezo, I could be about 10 years old. I do not know about the area of land while the said plot was sold to Saneo Kezo. After selling the said plot to Saneo, I know nothing from my father claiming this plot from us, from any other claiming this plot from us. I affirm that SBI is below the road, below the main road. This is true. So this is his deposition, and in cross also. And although he was called, he did not add any new statements. In the second time also he was called, but no new statement was given. He simply says, whatever I have stated in my cross-examination, I reiterate on the statement which I have given earlier, which I have given before. And in cross, whatever I have stated in my cross-examination in the earlier proceedings, I reiterate the same. So he has not added anything. So I examine Vechone and this Satoru. And the respondent his statement, we have read the additional statement and only the first part of his in chief statement in chief. Cross-examination part, Your Lordship, I'm allowed to read.
Page.
Page 100.
Yes.
In the meantime, late Huchuzu alleged that he had already purchased. Then after the cross-examination, history and facts of the case of Civil Revision 1/201 has been duly submitted by me and verified. So now here is the picture. I am the owner of that disputed land. I'm not aware of Saneo purchasing the plot from Pire GB in 1969. I'm not aware of Dachshune and Vechune selling the plot to GB Pire. I am the owner. I am not aware the exact date of the division of land between Futsonomi and Kunutsumi. The division of land has been demarcated from Bible HS Road to GHS Junction. The plot above the road, we do not have any claim. And I belong to Kunutsomi clan and have no possession above road except the disputed plot. Prior to civil case number 4885 in the court of P. Hang Sin, order dated 13/3/95, I have no case against Sanel. All the plot from Dachone and Vechone. In view of this dispute, the matter was referred to PA2DC Zugaza, late Kuhucho. He decided the case and he divided the plot, and a small portion where now Sanel have constructed new RCC roof building was given to Kereti. After that, Anye and Muzato again disputed with me for the same plot before ESC Future. Sanel presented before ESC court and admitted that he had purchased that plot of land from Future. After that, ESC divided the plot to my favor. After that decision, my elder brother, Mr. Bungor, sold my plot to one Anevero. After that, the matter was referred to ESC court, and since Kereti's consent was not taken, the plot was decided in my favor. After this, Sanel, GB Pire, Dachone, Vechone, without my knowledge, case before this court and obtained an order in favor of Sanel Kezo, and for which appeal was referred before the High Court. I am also to state that an empty plot near the house of Sanel and Huchozo belongs to Kereti, and there is no dispute. Anye had instituted 2 cases against me, and now he is dead. After the death of Anye, his brother's son and wife Anye have received rupees 2,600 from me to build his tombstone on their request, and in presence of witness, I paid the sum of rupees 2,600. Before he died, late Dachune had confessed that he also, with Vechone, had sold the land to Huchuzo, and the remaining plot is now sold to me, and that there is no further dispute case. This confession had been reduced in written with it, with left thumb impression, with late Dachune's thumb impression. May it be stated that the reason for returning the case against me by SDO Civil, after I produce the said confession made by Dachone to me, SDO Civil had also turned down the case. Thereafter, I started leveling of the said plot, during which time there was no complaint. Thereafter, when I started construction after dumping materials such as bricks, sand, road, and cement, then this Procedural Committee chairman stopping construction works on the ground that I am encroaching into the footpath of the public. After this, Mr. Sanyo, Dachune, Vechune, and Pire again obtained an order from ADC Hang Sin that the land belongs to Sanyo, which order was passed behind my back. Thereafter, I went to High Court, who cancelled the order of ADC Hang Sin. Sanyo was given 2 months to approach any competent court to substantiate his claim over the land. In future of complying to the order, the land was supposed to be declared in my favor. Instead of complying to order of the High Court, Sanyo started construction over the plot. I went and requested the SP pack about the construction, who informed the SDO, SDPO Fitzgerald to confirm the report. Thereafter, case was again pursued before the High Court. May it be mentioned that prior to the divisions of land amongst the Vero clan, it was formally agreed upon that any construction standing prior to the division in both sides, irrespective of both clans, Kunutsomi and Futsonomi, shall remain the same despite the divisions of the land. This agreement was inclusive of transactions affected with other clans as well before division. This plot in dispute had been declared in my favor after the case between myself and Hutsoze was settled by PA to DC Zugatsa. The disputed plot is mine because Dachone and Veshone had sold me their share. And now they sold their share to Dachone and Veshone sold their share to him. The share is the share and the land where Sano is residing now is the share of Hutsoze from where Sano purchased. It is also mentioned that the RCC building now is standing to my plot, which constructed by Sano. Despite High Court's order, Sano changes his stand in the High Court and in the lower courts in regard to the disputed plot. I reiterate that the disputed plot is my plot, and I pray for a justified judgment on the matter. Now, so what is his claim? First, he said he is the owner of the donated to the medical department. He wants to buy it back. Then he says he purchased from Dachone and Vechone. Then we will go to, then the documents, Annex B says, no, he has already stated. And additional present there. We have read the additional. Was for witness. His witness number
104.
Page 96 is respondents witness number 1, Krutoyo.
Yes.
The dispute between Sano Kezo and Keretivero, as far as I knew, the plot belongs to Keretivero and we all are of the Vero clan. In the past, there was a dispute between Vero clan and I'm aware and know that the dispute was settled amongst us in favor of Keretivero. And thereafter, since it was settled amongst ourselves in favor of Kereti, I also pray this court to settle the matter available, amicably or available. That whatever I have stated is all true to my knowledge. And if any query is necessary, I am willing to state before this court. That's all I have to say. And in cross-examination, I'm about 45 years now. I am in the knowledge of the dispute between Keretivero and Sana for a plot at Puchero. The plot in dispute is in front of and is opposite to SPI Puchero branch. We Veronomi Cal has divided the land at Puchero between us. Funutsomi clan owns the upper portion of Puchero. The land has been divided into 2 parts, and the demarcation runs from Bible HS to GHS road. The upper portion of the divided land belongs to Puchonomi clan of Vero, and the other half below the road belongs to Kunuzo clan of Veroni. I'm of Kunuzo. The plaintiff, Kirati, is from Kunuzo clan. Mr. Kirati, the plaintiff, has bought a plot above the road belonging to Kuchonomi clan. The plot in dispute has been bought by Kirati from Dachone and Ane. I do not know what time the plot was bought. I knew Sanel. It is affirmed that we Kunozomi clan, including Kirati, does not have any clan above the road, is from Bible HS Road to GHS Junction. I'm giving this statement in clear conscience without any prejudice. I do not know whether Sanel has ever purchased a plot from GBP. Now, his own witness says the respondent purchased from Dachone and Ane. Again, another has been added, not Dachone, but Dachone and Ane. And he has given a few additional, any additional statement? Yes. He has given additional statements. Page 98. It is true that in the earlier proceeding, I was one of the witnesses for the plaintiff Sri Kirati Vero. Whatever statements I have made were true and to the best of my knowledge. In addition to my earlier statement, I would like to add some additional statement. We Veronomi clan have a common land. Thereafter, we divided the common land by way of two ancestors, Futsonomi and Kunuzomi. That the land occupied by Futsonomi belongs to them even after the division of land, and the land of Kunuzomi belongs to them even if it falls under the divisions of land made. And there was no objection on either parties of Futsonomi and Kunuzomi. The land in dispute is above the road. The land in dispute was cut by my father and myself. And the same earth was moved out from a vehicle. At that point of time, there was no complaint.
What is meant by above the road and below the road? It is
Your Lordship?
the land above the road and below the road.
Yes.
It is in hilly area.
Hill areas. And so the main road passes from Kohima to Pek. So towards Kohima will be below the road.
Belonging to a different clan.
No, same clan, but
Two clans are there.
two clans. From Vero, there are two
two
clans.
sub-clans.
Yes. So one is Kunuzomi, and the Kunuzomi was given all the lands below the road. And Fuchonomi, they were given all above the road. Kohima Pek Road.
Okay.
Yes. The land in dispute is above the road. The land in dispute was cut by my father and myself. And the same earth was moved out from a vehicle. At that point of time, there was no complaint. After clearing the disputed plot and in bringing materials to build, Dachone and Vechone complained, and thereafter, Kirati paid money to Dachone and Vechone. Prior to them, there was no complaint. Only after the clearing and on the basis of the complaint, Kirati, in order to settle the matter, filed case in the court of law. So again here, one discrepancy which is important is this witness says his father and himself cut the land.
His son
But
of
he is the son of
Kumaro.
Kuchoyo. No, no, no.
No, he is Kutsoyo, son of Pumoro.
Yes. Yes.
Pumoro is the brother
Kuchoy,
of
yes.
Kiriti.
Yes. So himself and Father Kiriti got the land. And then Dachone and Vechone, they complained. So according to him, Kiriti paid them money. Now, where are those things? These are all, in fact, fictitious. Because if Dachone and Vechone sold it to Kiriti, then I'll be going against Dachone and Vechone. But Vechone and Dachone, they complain. And also I complain against Dachone and Vechone. But before the court of Angsing at the impact, it was clarified by GB Pire, Dachone, Vechone. So the 84, the alleged sale of 84 by Dachone, those are all makeups. Those are all makeups. Therefore, to prove the genuineness of those things is most important in accordance with law. Now, in cross-examination, I do not know the year and date. I do not know the year as to whom Kiriti paid the cost of land to Dachone and Vechone. I also do not know the amount paid to Dachone and Vechone. It could be more than 30 years. I cannot remember all, but I can remember some of my statement recorded the previous proceeding. It was a fact that my signature is appended on dated 12/8/2003. This is referring to his earlier first statement, wherein I am called as a witness. The disputed plot is opposite the SBI. The statement of the witness contradicts to the extent that as per statement made on 12/8/2003, it has been recorded and the signature verified by the witness. However, the statement given in the additional statement, the witness stated that his statement made as additional statement and disputed land was purchased by Gauhati from Dachone and Vechone. However, the statement recorded on 12/8/2003, his statement is being recorded. The plot in dispute has been bought by Gauhati from Dachone and Ane. So then next, the same is misleading and devoid of any credibility of a person and on oath as a witness for the plaintiff Gauhati. I know GB Pire. I do not know whether Sanor purchased land from GB Pire. Vengoyo of Puchonomi has a land in the land of Trunosomi. It also a fact that I cannot remember everything and that I also cannot remember the addition of new name which was recorded today, 29/3/2018. I do not see anything overwriting since last appearance before the court. I am thereafter ignorant. I reaffirm that whatever statement I have stated are true and stand by it. So that is, and the number 2, now the respondent in this additional statement denies of the existence of his witness number 2 to me that we have copy, but we don't have spare copy. Can we submit a copy tomorrow to the court? Yes. Anyway, let me read out that from the earlier paper book.
This is regarding
Statement of witness of the respondent.
you have not included in this paper book.
Your Lordship, because mistakenly we have said only two. But in the earlier paper book,
One more witness is
one
there.
more is there, three. That is our mistake. And he is number two, witness number two. His name is Nyi Vero. And this Nyi Vero, the additional
He
statement
is
of
not my witness. Kirti
re-
is saying that he is not his witness.
no, yes, that is correct. So now whether it is his witness or not, witness number two, name is Nyi Vero. With regard to the present dispute, as far as I know, the plot in
This
dispute
statement is before in
Before-
the
before
fake.
this
Decision
is
fake.
pack. Yes,
After the judgment against which this present appeal is there.
before
Or
that,
the
before.
earlier one.
yes, earlier one, the first one.
Okay.
With regard to the present dispute, as far as I know, the plot in dispute belongs to Kirti Vero. Dachone and Vechone are same group and Hutoze is the other group. They disputed the same plot and the dispute was settled by DB score and divided the same plot. After that, Sanyo purchased the share of Hutoze and constructed his residential building. Now, the present dispute belongs to Dachone and Vechone share. Kirti took the share of Dachone and Vechone. After that, I also cleared the said plot, which was taken by Kirti. When we were making the clearance of the said plot, Sanyo did not raise any objection. When we have cleared the plot and about to start the construction of the house, Sanyo started construction of the house in the cleared plot. Subsequent to this action done by Sanyo, the Sanyo told Sanyo that since the plot does not belong to you, you have no right to construct the house. Hence, the present dispute with which construction. In cross, I know that Sanyo has bought a plot from Hutoze on which he constructs his building and he resided in this building till date. The present plot in dispute is located near Old NST station in Procedural town. Kirti has given money to Dachone and Vechone and took possession of the disputed plot. Dachone and Vechone has given money for putting up of a memorial stone for their younger brother, but I do not know the exact amount. Now, earlier, the respondent said he gave money to late Anya's wife for the tombstone. Now, this witness says money was taken by Dachone and Vechone for memorial stone. The credibility of the statements of the witness, Your Lordship may kindly consider. The plot which we cleared was during 83 or 84. My father, Hupucho, is the elder brother of Kirti. So relatives, they are all relatives. There was a case between Dachone and Vechone and Hutoze. The above case may have been served 20 years back. I am from Krunotsomi clan and we have divided our land and our portion of land is below the main road from Bible College to GSHN Junction. Kirti is from Krunotsomi and Kirti has no share on the upper portion of the divided land. Land was divided amongst our Vero clan. Since Dachone and Vechone share lies above the road, and since Kirti have taken the share of them, Gauhati has become the absolute owner of share that belongs to Dutch owner and Dutch owner. Whatever I have said before the court is true to my knowledge. That is his statement. Now, why is the respondent denying that this person is not his witness? The credibility of the statement of the respondent himself. Where is his credibility? If the court sees these things, trial court, why not doubt the statements of the respondent's witnesses and the respondent's own statements? More from there. So these all problems started, as I stated in my appeal memo grounds, that in ground 10 of my appeal memo, 12, page 12. The others I have almost mentioned, but ground 10 also I have mentioned, page 12, ground 10. Because the trial court failed to notice that in the absence of a written statement, as required under the law, Sirikiri has been given to state anything he wants, and the trial court also failed to take note of the contradictory statements made by the Sirikiri as the evidence placed before the court have not been discussed at all. So the trial court cannot travel beyond the pleadings and the evidence placed before it. And therefore, in short, my main points of arguments in this appeal is the production of the manner of the production of the documents. One, then no notice was produced, no data was given. Then original was never produced. No witnesses in connection with the documents was examined. The respondent has never filed any written statement, and therefore traveling beyond, I cannot say traveling beyond, because there was no written statement. Now, how the court can examine? And since my petition in case number 48/1985 is to be treated as a plain. Now in that, I have given the schedule of the land. And I have also page
Page
57. Page 57. In paragraph 4, this is the schedule of the land. The exact area is 24 feet by 12. No, 12 is 7 is, I think that
this has to be, this,
to be treated as the plain.
the direction was that this should have been treated as. plain.
Yes. So the schedule of the land is there with boundaries. Then
And page,
page 58, starting from page 56, I'm sorry, 57. Then in the same paragraph, paragraph 4, this plot of land originally belonged to Dachone Vero and Dachone Vero, both sons of brothers, sold this plot of land to Sri Pirejibi of Kikruma village, and from Sri Pirejibi, this plot of land was purchased by Sri Sanoekezo in the year 1969, and since then till today, Sri Sanoekezo has been and is still in possession and enjoyment of this plot, of land as beneficial owner without any interruption from any quarter whatsoever. Hence, no right to sue existed against any of the aforesaid three persons, whatever. Now, this is the statement, the boundaries, the claims. Nowhere this is denied by way of written statement. Therefore, the case of this appellant has to be allowed. The case of this appellant is to be allowed. Now, regarding the main case argument is almost over, except for submission of some.
Additional, you have an I also.
Yes, so we'll continue with that, with the IA.
Your submission in main case is over.
It's almost done.
You will be giving bullet points only.
Yes, but I
Now,
would like to give.
what is the prayer? You have a prayer for allowing you to adduce additional.
Yes, that is one of my prayer in the IA. And in the main appeal memo, my prayer is to question, set aside the impinged judgment and to pass any other orders as deemed fit by the Honorable Court. Because I have not specifically asked for a remand, but in view of the nature of the case, now the documents especially, that has to be
You have not mentioned
only
any-
considered by the trial court.
But you have not mentioned anything about your prayer in I that.
Remand as
Why?
such specifically I've not mentioned, but I've said,
No, what you are praying for in the interlocutory application.
interlocutory application.
Ah,
Yes. Now,
in very brief,
this is under Rule 41, Order 41, Rule 27. Now, this cell deed, which I have enclosed, and originally I have enclosed before the court. This was found in possession of my eldest son. This was, I was never aware. In paragraph 4, I have given the reason why this should not be considered. In paragraph 4, Your Lordship, let me take your Lordship to paragraph 4.
paragraph 4 of the I.
Yes. Yes,
I,
yes. Page 3, paragraph 4.
how many IAs are?
1. There are also 2, other one, but those ones for stay of the
That is not
good order. Yes.
This IA is IA number
2. In 84, I'm sorry. Application IA number 84 in FA 2.
para.
Starting from paragraph 3.
Yes.
That the documents so to be produced before the Honorable Court are of substantial character to determine the real question in dispute between the contesting parties. That the applicant tried every means to locate the self-written documents over the years, but was unsuccessful. Also, the applicant was not aware that his son has kept his old files where past ancestral history were recorded. That the sale documents could be traced only on 31/7/2019 in the old file from his son's residence, who shifted out after his marriage sometime in 2005 and was in his possession of the same till then. Copies of
What this document is
this is a sell agreement,
regarding this
the
disputed land,
purchase from GBP Rank.
the land which you are claiming to have purchased.
Yes, in
GBP.
69, yes,
The disputed land.
yes,
So that 69 sale deed,
yes.
sale deed or agreement?
Agreement, it's written as agreement.
Okay.
Copies of the sale document in original between Pira and son applicant dated 5/12/1969, marked as annexure S1, because I've submitted the original before the court along with that application. Paragraph 5, that the written sale documents are documents which are required to determine real justice and the dispute to a logical conclusion. Also, if these documents are not allowed, then substantial damages would be caused upon the present applicant petitioner. That the non-production of the aforesaid documents before the trial court does not help this applicant in any manner whatsoever. And despite repeated diligent search to locate the said documents, it could not be traced. And as stated above, it was found from his son's residence. That the applicant could not remember when it was given to his son, nor was aware as to when his son has taken it. The son was also not aware at all that it was in his possession, and only on 31/7/2019, when the applicant, as a last resort, went through the old files containing the past ancestral history, recovered the documents. That the trial court rightly said that despite saying the existence of the sale and purchase documents, but if that is not produced in court, it would be presumed that such documents does not exist. However, having found the documents, finally, the applicant ought to be given an opportunity to produce before the honorable court by way of additional evidence that the documents sought to be produced are relevant and substantial in character to determine the real question of the dispute. It is also respectfully stated that seeking for production of additional documents are not to fill up lacuna or to patch up the weak points in the case. That the said documents are in existence at all times, even before the appellant joined this dispute in 1985. So the main reason is that it was in the box of my son, in my box, with in the file of these ancestral properties and these records. Now, the father also could not remember when it was, although he knew the time, the year of purchase, and the months. He also says date, but there is a date in mistake. So the appellant tried its best to locate, because by not producing this one, he does not benefit in any way. Rather, it will help the court for a proper adjudication. Either way. Therefore, it is because the Order 41, Rule 27, there are some options where an additional documents can be allowed to be produced. The CPC Order 41, Rule 27, may I read your lordship?
Oh, what is the objection to your prayer by the?
The objection is that.
They will explain, but what is the gist?
Yes.
On what ground they are?
Objection is that after so many years of litigation, he has never produced.
So this is not a genuine document.
This is not a genuine document.
Is that the objection?
In addition to that, what they are saying is that that sale agreement was of 79 and 69, sorry. And they allege that in 1972, the respondent applied for the quarter, 3-type quarter in 1972, which was vacated by the medical department in 1971. So if that belongs to the department in 1971, 72, then how come the
In 69,
sale could took place in 1969? That is their main objection. Now, my reply to that is that those are issues to be decided by the trial court, because whether this document is genuine or not, whether this is admissible or not, whether in 1971, 72, if that is the position, if 69 sale is possible or not, those things the trial court has to see. Otherwise, as a trial court, now, with all due respect, whether this court, honorable court, can look into those aspects, because this is a civil suit, this isn't a writ. So documents in its proper stage and in its proper form has to be examined by the appropriate forum. That will be my reply to that allegation. So it doesn't mean that by allowing this additional evidence, that is the end. No, by allowing this additional evidence, I'll have the opportunity to produce it before the court. The other party will have all the opportunity to object it to its admissibility, to its genuineness, everything will be available. So if it is not genuine, naturally it will be rejected. If it is forged, it will be rejected. And I'm ready to face that one. So that chance must be given to the appellant. That is my prayer, Your Lordship, because it will not prejudice the respondent also, because he will get all the opportunities to rebut, to object in whatever manner he wants. He can question its authenticity, whether it be admissible or not. If it is admitted, whether it can be proved or not. The contents, whether it can be proved or not, those things. So my humble submission and prayer is that these additional documents may kindly be allowed to be allowed the additional documents for consideration by the trial court. And since I have submitted the original to the court, that I may be allowed to substitute that original by a photocopy.
where is the original? It is along with. Oh, okay.
So in support of my arguments, I would like to place certain authorities before your lordship. The first one will be up to book list number 2 to 8. I've made photocopies, except number 1. Number 1 will be GLT 2018, volume 4. I'll read out only the relevant portions.
GLT 2018, volume 4, page.
Page starts from page 576. 576.
No, relevant para.
Relevant para is paragraph 13. This is in the case of Nyamo Kamduk versus Minj Lohi. 13. It is noticed that the learned trial court had admitted photocopy of the documents, some of which are not readable and not even compared with the original, and signed by the presiding officer of the court to identify the same. It is not even discernible from evidence as to whether the exhibited documents were admitted with objections or without objection on the adverse party of the adverse party. The documents upon which reliance is sought to be placed must be brought on the course of the case legally, because the documents do not prove themselves. Further, secondary evidence should not be accepted without sufficient reason being given for non-production of the original. And if the truth of the facts stated in a document is in issue, the same need to be proved by oral testimony. The oral testimony in deserving cases may well be appreciated with the aid of opinion of the handwriting expert on the disputed documents. That is book, please. And
Yes.
the others are, yes, photocopies. Flag A. Flag A is the first one. This is 2009 SCC, volume 9. Malay Kumar Ganguly versus Dr. Sukumar Mukherjee and others. Relevant portion is para 37. Para 37, placidum H and F. Placidum H and F, para 37, along with 40. Merit.
Para 37.
Para 37. It is true that ordinarily, if a party.
This is for criminal proceedings on.
Your Worship,
Para 37 relates to criminal proceedings.
no, 37, this is about documents, contents about the production of documents, admissibility and these things. Although it is originated as a criminal case, that is based on Evidence Act.
Yes.
It is true that ordinarily, if a party to an action does not object to a document being taken on record, and the same is marked as an exhibit, he is stopped and precluded from questioning the admissibility thereof at a later stage. It is, however, tried that a document becomes inadmissible in evidence unless the author thereof is examined. The contents thereof cannot be held to have been proved unless he is examined and subject to cross-examination in a court of law. The documents which is otherwise inadmissible cannot be taken in evidence only because no objection to the admissibility thereof was taken. Then paragraph 40. Referring to RVE Venkatachala case, it's said, ordinarily, an objection to an admissibility of evidence should be taken when it is tendered,
and not subsequently. The objections as to admissibility of documents in evidence may be classified into two classes. One, an objection that the document which is sought to be proved is itself inadmissible in evidence. And two, where the objection does not dispute the admissibility of the document in evidence, but is directed towards the mode of proof, alleging the same to be irregular or insufficient. In the first case, merely because a document has been marked as an exhibit, an objection as to its admissibility is not excluded and is available to be raised even at a later stage or even in appeal or revision. In the latter case, the objection should be taken when the evidence is tendered, and once the document has been admitted in evidence and marked as an exhibit, the objection should not have been admitted. No, objection that it should not have been admitted in evidence or that the mode adopted for proving the document is irregular cannot be allowed to be raised at any stage subsequent to the marking of the document as an exhibit. Then Placitum F, Your Lordship. Placitum F. In the first case, acquiescence would be no bar to raising the objection in a superior court. And the first case is at the top of the line, an objection that the document which is sought to be proved is itself inadmissible in evidence. This one. So acquiescence will not bar raising such an admissibility in a superior court.
Yes.
Next one is flag B. Flag B. In the case of Life Insurance Corporation of India, another versus Rampal Singh Bisan. Flag B, para 25, 27, 31. Para 25. Para 25. We are of the firm opinion that mere admission of a document in evidence does not amount to its proof. In other words, mere marking of exhibit on a document does not dispense with its proof, which is required to be done in accordance with law. 27. It was the duty of the appellant to have proved the documents, exhibits A1 to A10 in accordance with law. Filing of the inquiry report of the evidence adduced during the domestic inquiry would not partake the character of admissible evidence in a court of law. That documentary evidence was also required to be proved by the appellant in accordance with the provisions of the Evidence Act, which they have failed to do. Then 31. Under the law of evidence, also, it is necessary that contents of documents are required to be proved either by primary or by secondary evidence. And at the most, admission of documents may amount to admission of contents, but not its truth. Documents having not been produced and marked as required under the Evidence Act cannot be relied upon by the court. Contents of the documents cannot be proved by merely filing in a court. Then flag C. This is 1997 SC, Jaipur Development Authority. Your Lordship, let me read, say it together, because this pertains to Order 41, Rule 27. Let me refer this. Paragraph 4 and 6. Paragraph 4. We are of the view that the interpretation put in by the High Court of Rajasthan and the High Court of Gauhati on the word additional in clause AA of Order 41, Rule 27 CPC is not correct. Then 6. The intention of the sub-rule, in our view, is that a party who, for the reasons mentioned in the subclause, was unable to produce the evidence in the trial court, should be enabled to produce the same in the appellate court. The sub-rule mentions the conditions which must be complied with by the party producing the additional evidence, namely that notwithstanding the exercise of due diligence, such evidence was not within his knowledge or could not, after the exercise of due diligence, be produced by him in the trial court. It is not one of the conditions that the party seeking to introduce additional evidence must have also been one who has left some evidence in trial court. Such a view amounts to introducing an additional condition not contemplated by the sub-rule. No distinction was intended by the sub-rule between a party who has produced some evidence in the trial court and one who has adduced no evidence in the trial court. All that is required is that the conditions mentioned in the body of the sub-rule must be proved to exist. It is not permissible to restrict clause AA for the benefit of only those who have adduced some evidence in the trial court. Now, the Gauhati High Court is that there must be some evidence, some sort of evidence. I think that was the case in the Gauhati High Court, which was found to be not correct. Then, flag D, this also on procedural aspect. This is 2003 SCC, para 26A. Yeah. For 26, let me start from 26. Laws of procedure are meant to regulate, effectively assist and aid the object of doing substantial and real justice, and not to foreclose even an adjudication on merits of substantial rights of citizens under personal property and other laws. Procedure has always been viewed as the handmaid of justice and not meant to hamper the cause of justice or sanctify miscarriage of justice. A careful reading of the provisions contained in Order 22 CPC, as well as the subsequent amendments thereto, would lend credit and support to the view that they were devised to ensure their continuation and culmination in an effective adjudication, and not to retard the further progress of the proceedings, and thereby non-suit the others similarly placed, as long as their distinct and independent rights to property or any claim remains intact and not lost forever due to the death of one or the other in the proceedings. That much only. Then like E, 31. Oh yes, 31.
Paragraph 31. But in our view also, as to what those circumstances are to be, cannot be exhaustively enumerated, and no hard and fast rule for invariable application can be devised. With the march and progress of law, the new horizons explored and modalities discerned, and the fact that the procedural laws must be liberally construed to really serve as handmaid, making workable and advance the end of justice, technical objections which tend to be stumbling blocks to defeat and deny substantial and effective justice should be strictly viewed for being discouraged, except for the mandate of law inevitably necessitates it. Then flag E. Paragraph 36. Starting from paragraph 36. Order 1 for Rule 27 CPC. The general principle is that the appellate court should not travel outside the record of the lower court and cannot take any evidence in appeal. However, as an exception, Order 41 Rule 27 CPC enables the appellate court to take additional evidence in exceptional circumstances. The appellate court may permit additional evidence only and only if the conditions laid down in this rule are found to exist. The parties are not entitled as of right to the admissions of such evidence. Thus, the provision does not apply when, on the basis of the evidence on record, the appellate court can pronounce a satisfactory judgment. The matter is entirely within the discretion of the court and is to be used sparingly. Such a discretion is only a judicial discretion circumscribed by the limitation specified in rule itself. 38. Order for 41 Rule 27 CPC, the appellate court has the power to allow the document to be produced and a witness to be examined. But the requirement of the said court must be limited to those cases where it found it necessary to obtain such evidence for enabling it to pronounce judgment. This provision does not entitle the appellate court to let in fresh evidence at the appellate stage, where even without such evidence, it can pronounce judgment in a case. It does not entitle the appellate court to let in fresh evidence only for the purpose of pronouncing judgment in a particular way. In other words, it is only for removing a lacuna in the evidence that the appellate court is empowered to admit additional evidence. Then, paragraph 77. This court, while dealing with an issue in Kalyan Singh Chauhan versus CP Joshi, after placing reliance on a very large number of its earlier judgments, including so and so, held that relief not founded on the pleadings cannot be granted. A decision of a case cannot be based on grounds outside the pleadings of the parties. No evidence is permissible to be taken on record in the absence of the pleadings. In that respect, no party can be permitted to travel beyond its pleadings, and that all necessary and material facts should be pleaded by the party in support of the case set up by it. It was further held that where the evidence was not in line of the pleadings,
the said evidence cannot be looked into or relied upon. 78. In Bagjaj Nahar versus Nilima Mandal, this court held that a case not specifically pleaded can be considered by the court unless the pleadings in substance contain the necessary averments to make out a particular case and issue has been framed on that point. In the absence of pleadings, the court cannot make out a case not pleaded suo motu. Then flag F. This is our High Court case reported in 2011 1 GLT, paragraph 19 and 21. Para 21. Para 21, sorry. Para 21. After discussing several earlier decided cases on this production of documents and proof, the learned court has come to its finding at paragraph 21. The sum total of the above discussions leads to this court to the inevitable conclusion that the paper marked documents A, B, C, D, E, F, G, and I relied on by the respondents cannot be regarded as accepted as admissible evidence under law, inasmuch as they are neither primary evidence nor admissible as secondary evidence in terms of the requirements of Chapters 5 of the Indian Evidence Act. Consequently, the judgment of the First Appellate Court, which reversed the judgment and decree of the trial court, primarily on the basis of the contents of those paper-marked documents, is liable to be interfered with, even at the cost of repetition. I'm inclined to echo the pronouncement contained in the state of Meghalaya versus others versus Joint Manik Nosmilgiri, that utilization of such documents which are bereft of the sanctity of any evidentiary value may give rise to dangerous precedent in the field of civil litigation, injuring the rights of many. Then the last one is government of AP versus Harijina Venkata, 1995 SCC. Flag G. Page 462.
Para,
But to shorten the time, I read only para 2. We have heard the learned counsel.
no, nothing to shorten. You have taken sufficient time.
Yes, but
Yes, para,
para 2.
para two.
We have heard the learned counsel for parties. Two questions arise. One, if the additional documents would have been admitted in great jurisdiction, and second, if credence could be placed on them as they were only photostat copies. And the High Court admitted the documents without recording any finding that the respondents made out a case for acceptance of secondary evidence. The admission of additional documents by the High Court in writ jurisdiction is an exercise of discretion with which this court does not normally interfere. But
the genuineness of documents is an aspect which goes to the root of the matter. If the records have been tampered and fictitious documents were produced before the High Court, then it certainly vitiates the finding. In our opinion, in absence of any finding on it, maybe because it was not raised in the High Court, yet being a fundamental question, which, if found to be correct, would render entire proceedings bad. It appears expedient to direct the Commissioner of Survey and Settlement to examine it after affording opportunity to both sides to lead evidence. The findings shall be recorded after examining the original records. So, so far in connection with this, the evidence, the procedure. Now, I have not enclosed this, but allow me to read out in the case of Shanmugam, as reflected in the 2012 SCC.
2012
SCC,
volume,
volume 6,
page,
page 430. 430, paragraph 24, from 24. This is a guide for the trial courts. Entire journey of a judge is to discern the truth. The entire journey of a judge is to discern the truth from the pleadings, documents, and arguments of the parties. Truth is the basis of the justice delivery system. This court in so and so, in para 1, said, truth constitutes an integral part of the justice delivery system, which was invoked in the pre-independence era. And the people used to feel proud to tell the truth in the courts, irrespective of the consequences. However, post-independence period has seen drastic changes in our value system. 25. This court in Margarida Sequeira Fernandez had an occasion to deal with the same aspect. According to us, observations in para 23, 32 to 52 are absolutely germane, and this paragraph deal with relevant cases which have enormous bearing on the facts of this case. So these paragraphs are reproduced hereunder. In this unfortunate litigation, the court's serious endeavor has to be to find out where in fact the truth lies. The truth should be the guideline star in the entire judicial process. Truth alone has to be the foundation of justice. The entire judicial system has been created only to discern and find out the real truth. Judges at all levels have to seriously engage themselves in the journey of discovering the truth. That is their mandate, obligation, and bounden duty. Justice system will require credibility only when people will be convinced that the justice is based on the foundation of truth. In Mohanlal Samji Soni versus Union of India, this court observed that in such a situation, a question that arises for consideration is whether the presiding officer of a court should simply sit as a mere umpire and a contest between two parties and declare at the end of the combat who has won and who has lost, or is there not any legal duty of his own, independent of the parties, to take an active role in the proceedings in finding out the truth and administering justice? It is a well accepted and settled principle that a court must discharge its statutory functions, whether discretionary or obligatory, according to law in dispensing justice, because it is the duty of a court not only to do justice, but also to ensure that justice is being done. What people expect is that the court should discharge its obligations to find out where in fact the truth lies. Right from inception of the judicial system, it has been accepted that discovery, vindication, and establishment of truth are the main purpose underlying the existence of the Court of Justice. So the more, but so your lordship. Now, what did the trial court did? The trial court, the presiding judge said, just observe, and finally, on the basis of his opinions of the going through without discussing evidence, came to his conclusion. So the impugned judgment is liable to be dismissed, and the additional evidence, the IA, may kindly be allowed, because your lordship, that is the discretion of the court. As the Supreme Court says, there is no legal right to demand for it, but depending on the facts of the case.
No, now what is your prayer? To dismiss the appeal?
Dismiss.
If the appeal is dismissed, your interlocutory application.
No. Did I say dismiss? To, I'm sorry. To dismiss the impugned judgment passed by the trial court and allow the interim application.
Now,
So that
suppose your appeal is allowed, what would be the consequences?
the consequences, your lordship, since because of the
If the impugned order is set aside,
the best course would be to remand the case
Remand.
for production of documents.
No,
Because and then there are various
no, that I want to understand. If your main prayer is allowed in appeal,
yes.
then your additional evidence prayer goes, because that would be only for the appellate court. Additional evidence is only for the appellate court. Your interlocutory application prayer
Yes.
is for the benefit of the appellate court to come to a decision, this court,
Yes.
this court.
Yes.
But before deciding that interlocutory application, if suppose this court allows your appeal,
Hmm.
then nothing remains in your interlocutory application.
Allows my appeal.
Both cannot be allowed. That is my query.
Your lordship.
Whether both can be decided in your favor.
That as far as interlocutory application concerned, it is the
Suppose your
discretion of
appeal
the
is,
court.
your appeal is allowed.
Yes.
What is the consequence? One consequence is it may be remanded back.
Yes.
Other is the appellate court's order may simply be set aside.
Yes. Yes.
If it is set aside and
Yes.
no order of remand is passed,
Yes.
then your prayer for additional evidence does not have a
Yes.
necessity.
Yes. In that case, yes.
I'm not answering, I'm putting questions on this.
Yes, I have understood. So that is to be decided by your lordship, I believe, because I cannot say allow this and reject this. Because in the
No, no,
interest
no,
of justice, your lordship
Just
may
I want to
consider
understand
in which way.
because I have heard you on the main appeal actually.
Yes.
Your submission regarding IA is is only during the last part, only few minutes you have stated what you are praying for in IA also, but you have made full submission in your appeal. Now,
Yes.
suppose appeal is allowed,
Yes.
then whether still you press for your prayer in IA, that is my query.
If the appeal is allowed, then I believe there'll be no point for pressing for the IA.
Yes,
Yes.
I just wanted to
Yes.
know that. Okay, you are done with finish.
Yes, I believe. Obliged, much obliged.
Now, Mr. Jamil.
We have only about 10 minutes, but I will not take 10 minutes. If with the permission of this honorable court, let me start tomorrow so that there can be a consistent flow of submission. But tomorrow is a division bench day. So subject to the convenience of your lordship, if tomorrow also in case,
It is
if the division bench rise early,
gets early.
then lordship may here take up this case tomorrow so as to maintain the continuity.
I am ready, subject to what both learned.
I hope my learned friend will also agree to that.
That is okay. That is all right with me.
That is
Only
one
thing is
aspect.
that there will be
Yes.
some hearing items in the DB.
Then we may hear it tomorrow. also.
Yes,
Yes.
whatever points and arguments my learned friend has raised today, all these points ought to happen raised during the trial. But in spite of the full and ample opportunity afforded to them, they have not raised these points before the trial court and before the appellate court they are raising. Now, my learned friend has just now relied on certain judgments
You will start
under,
now.
under pleadings.
Yours.
Under pleadings. And my submission is, this appeal is to be heard on the basis of the grounds taken in the appeal and on the basis of the records available. Now, my learned friend has placed one judgment which says that if there is no pleading, then there should be no consideration without any pleading. That is a general principle of law. I fully subscribe the citation which my learned friend has cited. Therefore, giving in view of that principle, this appeal, the present appeal, has to be heard in that spirit, including the prayer portion, where they have made a prayer to set aside and quash the order passed by the district judge Peck, and there is no prayer for remand. In the main prayer, I have seen, Lordship may kindly see the prayer. What is the prayer? Page 13. My learned friend has cited the ruling that if there is no pleading, then there should be no consideration. So
So your submission
I'm
is,
supporting his citation, saying that since even if they succeed, there is no prayer for remand. And few things are accepted and agreed by all the parties. Few facts are certain. That is, this litigation is lingering for the last 48 years. Just 2 years to reach half a century mark. Since 1975, this litigation is lingering. I joined in this litigation in the year 2005, when the matter was transferred from Peck to Kohima to the ADCJ. So I joined from that stage. But before me, my learned friend was conducting the case. He joined, I believe, in early 90s. From that it is 90s.
Time.
Now,
After that, I was out again.
the area of the land is 24 by 12 feet only. And nobody is disagreeing to that. It is certain that area of the disputed land is 24 by 12. And there was 12 litigations over the years, 9 proceedings in the High Court and 3 proceedings in the trial court. That too before the district judges. Now, in all these proceedings, the appellant has succeeded only once before the additional district magistrate Peck. That too, when he succeeded, that was an ex parte order. It was an ex parte order, which I have challenged and I have succeeded ultimately. And another important fact is that, which is admitted by all, and there is no dispute about it. The appellant has constructed a building in the disputed site during the trial before the district judge Pack. He was cross-examined and he has admitted to the fact that, yes, I have constructed the building in violation of the order passed by the Honorable High Court. That is an admitted position which he has deposed during the trial. That was in the cross-examination and High Court order is there. Whatever has been done, the High Court order has not been challenged by the appellant. He has admitted. And this is a dispute among the brothers only, among the family members. Because Tachuni and Bichuni and Kereti Vero, they all belong to the same clan from one village only. They have common land. That was vacated. Now, another important incident. In the year 2016, when this matter was pending before the Honorable Court, before it was remanded back to the District Judge Pack, my Lord Justice P.K. Saikya, he invited both the parties that, yes, look, for a small plot of land, you are fighting for the last more than 40 years. Why not you arrive to an understanding? That was the suggestion. So there was a hearing in camera. All of us were invited to the chamber. Of course, Sanyu Kizo, he is no more. But when he was alive, he was also called. My client Keriti Viro was also called. Both the councils were there. And then my Lord Justice P.K. Saikya has put two queries, one query each to put up there. To the appellant, the Sanyu, my Lord Justice Saikya has asked a question, put a specific query. Why you have constructed the building in violation of the High Court order? He has not uttered even a single word, the appellant, present appellant. Then next, my client's turn, that is Kereti Vero. My Lord Justice Saikya put the question. Why not you compromise among yourselves? Because you have been fighting over the years for the last more than 40 years for this small plot of land. Admittedly, it is a commercial plot, and the appellant is benefiting all throughout the litigations by deriving rent from there. Now, my client replied, look, I have been fighting for this case for the last more than 40 years. And if at this stage I compromise in any way, this way or that way, then a presumption will be drawn by the public that, look, what he has been fighting without having any cause. He has been fighting without any reason. Therefore, since the matter is pending before the Temple of Justice, let this Honorable Court decide this case after examining all the evidence and points. That was the reply from my client. Fortunately, he is still alive. He is 91 years old. And only a few days back, he visited my chamber. And he has told me one thing, very emotional also. My counsel, I would like to see the justice before I die. Why the matter is being delayed so much? I find it very difficult to answer, but then due to the reasons beyond my control, the matter has been delayed. Because immediately after the admission, we were under the impression that this matter will be taken up. But then COVID came, it was nobody's making. So as luck would have it, the matter could not be heard, and then it has taken for so long. And my learned friend has made this emotional expression that even if I have lost many times, even if the matter is pending for a long time, court should not be driven by such submissions. Now, what is emotion, Lordship? Emotional expression without any reason, without any basis. If I decide something, if I do something, That is emotional reaction. But can anybody ignore 40 years, 48 years, long litigation history? Can that be taken easily? That useless, 48 years, that we are concerned. Why so long this matter is triggered? In spite of orders after orders, the person, the legitimate owner of the land, could not enjoy his property. When he will enjoy? After his death? Suddenly not. And execution proceeding is pending before a district judge. But then, in view of pendency of this, that we have it with court conscience, we have withhold that proceeding. Otherwise, there is no stay. But we respect this honorable court that yes, there has to be sanctity. Sanctity should be maintained.
Okay, we'll,
Therefore,
we'll,
let us wait.
we'll continue tomorrow.
Lordship, my submission will be different than my learned friend because my learned friend has referred to all the documents. So tomorrow I will refer only to 3 judgments, 2 orders, judgment and order passed by 2 decrees, passed by the 2 district judges, and the order.
He has also already gone through the history.
No, Lordship,
If
one
something-
important, the second one, I agree. My learned friend has gone through, read out all the judgment, but
whatever he has left, you make.
yes, only one. And then the honorable courts, this honorable court's judgment by which remand was made. So this, I will refer to these orders only. And in the meantime, in the course of reading those judgments, I will just make my submission also. And the moment I finish reading, hopefully my submission may be over. So my style of submission will be shorter than what my learned friend has made. And then to the possible extent, I will try to make it very short and also a little background how the land dispute started. That I will start with that
That will be
tomorrow.
necessary.
Much
Okay.
obliged.
Heard Mr. R. Eralu, learned senior counsel for the appellant, assisted by Mr. Elivel Zhao. Also heard Ms. C.T. Zamir, learned senior counsel for the respondent, assisted by Mr. N. Longkumar. The hearing remained inconclusive. Let this matter be fixed tomorrow after the rising of division bench
As part.
as part heard matter.
Very obliged.